Good morning. How you doing?
Good, how are you?
Doing pretty good. I don't know if you got my chat or not, but I sent you a chat requesting to get the juvenile done first, since he can't be in the same area or seen by the male inmates. I'm sorry, adult inmates.
Okay. No
Okay.
problem. I still need to, I guess, swear everyone in, but I guess I can do, if we do him first, then can you have both the male and the female so I can swear everyone in at once?
Yes, ma'am.
Okay.
All right.
Okay, let's do that. Good morning. My name, can you hear me, sir?
Mm-hmm.
Okay, good morning. My name is Judge Tamika West, and I am a magistrate court judge here in Clayton County. The purpose of the hearing today is to give you your first appearance. So first, before I begin, let me swear you in. So please raise your right hand. So I can see it. Raise it high.
As far as you get, go your
Okay. Okay, sorry. Okay. Do you swear and affirm that the information included in your application for court-appointed counsel, as well as any information that you give to this court, will be true and accurate?
Yes, ma'am.
Okay, thank you. Now, first, I would like to give you your statement of rights with respect to your first appearance. Please listen carefully, since it affects your rights and the reason why we are here today. This is your first appearance before the Magistrate Court of Clayton County. We are not here to try your case or to take a plea. You are here for the court to inform you of the charges against you, advise you of certain rights, set bail on those offenses for which this court is authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during these proceedings can be used against you if your case goes to trial. During this and all other proceedings, you have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. You have the right to indictment by a grand jury for most felonies or accusation for misdemeanor. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine witnesses who are called to testify against you. You have the right to compel the attendance of witnesses in your own behalf by subpoena. You have the right to testify and offer other evidence in your own defense should you choose to do so. But should you choose not to do so, there will be no presumption of your guilt may be raised. You have the right to have an attorney represent you. At this point, we will appoint an attorney to represent you if you're eligible. You will be allowed to post unrestricted bonds for your release from jail pending prosecution of your case, which may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond in cash together with applicable mandated fees to the sheriff's office, who will hold it until your final court date, at which time the cash bond will be returned to the person who posted it. If you use a commercial bonding company approved by the sheriff, someone will have to pay the company up to 15% of the total bond amount as their fee for the service. This fee will not be returned. You may also post bond using property if they have net equity in the property in an amount equal to 3 times the total bond amount. Some of you may have certain conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You also may be prohibited from calling or having contact with the victim while you're in jail. Should you violate the court order, your bond will be revoked and you will not be entitled to another bond while awaiting trial. An additional charge of aggravated stalking, influences witnesses, or other charges, as the law may provide, could be brought against you, for which you could be sentenced up to 10 years in prison and fined up to $20,000.
Can you repeat that one more time for me?
Yes. An additional charge of aggravated stalking, influencing witnesses, or other charges, as the law may provide, could be brought against you, for which you could be sentenced up to 10 years in prison and fined up to $20,000. That's if you violate the conditions of your bond. You understand that if bond is set for you today, you understand that?
No.
Okay. If you are charged with an offense for which this court is not authorized to set bail by law, then the bond hearing will be scheduled before a superior court judge and you will be informed of that date. If you're currently on active probation, this court is not authorized to set bond. Your bond can be reconsidered after your probation officer has an opportunity to determine if they wish to file a warrant for violation of your probation, usually during your preliminary hearing. The purpose of a preliminary hearing is to determine if there is enough evidence or a probable cause to justify keeping you in jail until such time as your case goes to trial. If you're charged with a misdemeanor only, you will have the option of waiving your preliminary hearing. Waiving your preliminary hearing will not affect your rights to post bond, your right to have an attorney represent you if you qualify for one, or your right to a jury by trial. If you post bond, your preliminary hearing is automatically waived and you will be mailed a notice when to appear in state court for arraignment. If you cannot make bond, you may waive your preliminary hearing and be taken before a state court judge, at which time, if you plead guilty, you will be sentenced. If you plead not guilty, a trial will be scheduled. If you are charged with a felony offense, you will not have the option of waiving your preliminary hearing. In that case, your preliminary hearing will be scheduled for November the 18th, 2021 at 8:30 a.m. And then your bond hearing will be scheduled for December 3rd, 2021 at 8:30 a.m. Please state, I'm sorry, go ahead.
Can I ask somebody to write that down for me?
Well, you'll get a copy of the order that I signed, okay? With that, with informing you of the conditions upon which you will be released or not. Okay, please state your full name for the record.
Jacob Gaston.
Okay, can you spell that for me?
Jacob.
Okay, last name?
Gaston.
Okay. Mr. Gaston, you've been charged with one count of armed robbery, which is considered a felony offense. Unfortunately, in light of the nature of your offense, this court, the magistrate court, is not authorized to set bail for you today. Only a superior court judge can set bail for you. You're okay. Your first preliminary hearing before a superior court judge will be scheduled for November the 18th, 2021 at 8:30 a.m. And then your bond hearing will be scheduled for December 3rd, 2021 at 8:30 a.m. Do you understand the charge as well as the no bond?
Mm-hmm.
You say yes? Okay. And then do you understand your two different hearing dates?
I'm saying November 18th and December 3rd.
Okay, tell me what is the first hearing date? What do you think the purpose of that hearing is?
I know
Okay.
the second one's for a bond hearing.
Okay. And what does that mean when you say, what do you think that means when you say for a bond hearing?
To see if I'm eligible for a bond or not.
Okay, correct. So the first hearing date, which is November 18, 2021, the purpose of that hearing is to determine if there's enough evidence to continue to detain you in jail. You understand the two difference?
Yes, ma'am.
Okay. Also, I'll need to determine today if you qualify for a court-appointed attorney. Unfortunately, because we did not receive the paperwork prior in my preparation for first appearance today, I'm going to need to ask you some questions to see if you qualify for a court-appointed counsel. Is that okay if I ask you some questions to see if you qualify for court-appointed counsel?
Yes, ma'am.
Okay. Okay, I have your date of birth as May 26, 2005. Is that correct?
Yes, ma'am.
And I have your, give me your street address, your home address.
8330 Attica Court, APPITA Court.
And give me your telephone number.
My 470 701-5421.
Okay, and do you have a job?
Yes, ma'am.
You do? Okay. Where do you work?
Six Flags.
Six Flags?
Yes, ma'am.
And is that part-time or full-time?
Part-time.
And what is your weekly, can you tell me your weekly wages?
So around like 250 to like 300.
200 to 300 a week? Okay. Do you have money in cash that is obtainable from any other source? Like, do you have any cash either on you or from any other source?
Okay.
Do you own any real estate?
No, ma'am.
Do you have an automobile or any other personal property?
No, ma'am.
How old are you?
15.
15?
16.
16? Okay. Do you have any relatives that could help you with the cost of your defense?
Yes, ma'am.
And then what effort, if any, have you made to get an attorney to represent you?
This is my first time being locked up, so I don't even know what that means.
Okay. Okay. So let me explain. Well, like, have you made any calls? Have you talked to anyone about getting you an attorney?
No, I just talked to my mom about, I only talked to my mom. My mom didn't even know how to put.
Okay. Did you talk to your mom about getting you an attorney? Okay. Okay. Based on your responses, you do qualify for a court-appointed counsel, so I will go ahead and approve that request for court-appointed attorney. Do you know what a court-appointed attorney is?
Mm-hmm.
So a court-appointed attorney is an attorney that's appointed by the state to represent you at no cost. You understand that?
Mm-hmm.
Okay. Do you have any question? You say no? Okay. Okay. Thank you, Mr. Gaston. Okay, deputies, are we ready?
Yes, ma'am.
Okay, and we have both the males and females.
Yes, ma'am.
Okay, great. Good morning. My name is Judge Tamika West, and I am an associate judge in Clayton County Magistrate Court. I will be presiding over your first appearance today. If everyone will please raise their right hand so I can swear them in, and please be advised that we are streaming. This is being broadcast live online. Okay, thank you. Keep your hands up, everyone. Keep your hands up so I can swear you in. Do you swear and affirm that the information included in your court-appointed counsel form, as well as the information that you give to this court today, will be true and accurate? Okay, thank you. You can put your hands down. I would like to make some opening remarks before we begin your first appearance today. This is your first appearance before Clayton County Magistrate Court, as I indicated earlier. We are not here to try your case or to take a plea. You are here for the court to inform you of the charges against you, advise you of certain rights, set bail on those offenses for which this court is authorized to set bail, to schedule your preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during these proceedings may be used against you if your case goes to trial. During this and all other proceedings, you have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. You have the right to indictment by the grand jury for most felonies or accusations for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine witnesses who are called to testify against you. You have the right to compel the attendance of witnesses in your own behalf by subpoena. You have the right to testify and offer other evidence in your own defense should you choose to do so. But should you choose not to do so, no presumption of your guilt may be raised. You also have the right to have an attorney represent you. If you qualify for a court-appointed attorney, we will appoint an attorney to represent you. Some of you will be allowed to post unrestricted bonds for your release from jail pending prosecution of your case, which may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond in cash, together with any applicable mandated fees, to the sheriff's office, who will hold it until your final court date, at which time the cash bond will be returned to the person who posted it. If you use a commercial bonding company approved by the sheriff, someone will have to pay the company up to 15% of the total bond as their fee for their service. This fee will not be returned. Some of you may post a bond using property if you have net equity in the property in an amount equal to 3 times the total bond amount. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to or around certain places. This is a special condition that will be provided on your bond order. You will also be prohibited from calling or having any contact with the alleged victim while you're in jail. Should you violate the court's order, your bond will be revoked, as you will not be entitled to another bond while awaiting trial. An additional charge of aggravated stalking, influence of witnesses, or other charges as the law may provide could be brought against you if you violate the terms and conditions of your bond order, for which you could be sentenced up to 10 years in prison and fined up to $20,000. For family members who will assist you in posting bond, they will be provided with information of your bond amount after we have concluded the first appearance calendar for today. If a family member is a victim on the warrant and there is a special condition that you're to have no contact with that family member, he or she will not be allowed to post bond. Again, if a family member is a victim on the warrant and there is a special condition that you're to have no contact with that family member, he or she will not be allowed to post bond for you. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled for a superior court judge, and you will be informed of that date at your first appearance. Some of you are charged, if you are currently on active probation, the court is not authorized to set bond. Your bond can be reconsidered after your probation officer has had the opportunity to determine if they wish to file a warrant for violation of your probation, usually during your preliminary hearing. The purpose of a preliminary hearing is to determine if there is enough evidence or probable cause to justify keeping you detained until such time as your case goes to trial. For those of you charged with misdemeanors only, you will have the option of waiving your preliminary hearing. Waiving your preliminary hearing will not affect your rights to post bond, your rights to have an attorney represent you, if you qualify for one, or a court-appointed attorney, or your right to a jury trial. If you post bond, your preliminary hearing is automatically waived, and you'll be mailed a notice when to appear in state court for your arraignment. If you cannot make bond, you may waive your preliminary hearing and be taken before a state court judge, at which time, if you plead guilty, you will be sentenced. If you plead not guilty, a trial will be scheduled on your behalf. If you choose to have a misdemeanor preliminary hearing, the hearing will be scheduled for November the 30th, 2021 at 8:30 a.m. For those of you charged with felony offenses, you will not have the option of waiving your preliminary hearing. Your preliminary hearing will be scheduled for November 18th, 2021 at 8:30 a.m. If you are denied bond today, you will also be given your date for your bond hearing. The bond hearing will be scheduled for December 3rd, 2021. That concludes my opening remarks. I will take the first individual deputy. If you have them, please state their full name for the record. Oh, and I'm sorry, before we take the first individual, you stated that there was an inmate or two that needed an interpreter. Can you identify them by name?
Yes, his name was Brian.
I'm sorry, I didn't hear you.
It was Brian Andra.
And right here.
You said Bryant?
The interpreter.
Yes.
What was your name? Estella
Duarte.
Duarte. Estella Duarte.
Okay,
And what's your name, sir?
so we will do her last. Anyone else?
Close.
Venga aquí.
Nombre.
Okay, state your full name for the record.
Name.
Nombre.
Jorge Alberto Baño Jackson.
I'm sorry, I didn't hear him, deputy.
Nombre.
Jorge Alberto Baño Jackson.
Okay. Can you spell that for me?
The last name. B-A-N-O.
BANOS
Okay.
YAXGE JORGE ALBERTO.
Okay. So we will take him last. I will do him last on the male side, and then I will do
Yeah. Okay, what do you last?
the female inmate that needs an interpreter. I will do her last on the female side.
Yes, Your Honor. We also have an inmate that has needs a sign language interpreter.
Okay. Now who would that be?
That would be Bryant Andra.
Spell that for me.
Bryant, BRYANT. First name Andra, ANDRA.
We're last. Yeah. You'll both together and do
Okay. Okay.
Go back. You probably need about, I think, 15 minutes.
Okay, before I take first inmate, let me briefly go off the record so I can see how do I coordinate a sign language interpreter.
Yes, Your Honor.
Okay. And we'll also take that individual last. And then we have 3 that are scheduled for, that need an extradition hearing.
We have 2, Your Honor.
Okay, I have 3 on my list. Oh, okay, that includes Ms. Bryant.
Oh, okay.
I have 3 on my list. I have Blunt, Bryant, and Shabia?
Shabika?
Yes.
We don't have a extradition paperwork for that one yet.
You don't have the extradition paperwork for that inmate?
We're gonna go get it, Your Honor.
Let's go.
Which one?
For the Shabika one. That's a whole.
Y'all making me work today. We need to get this paperwork in on time. Okay, so we would then definitely do, let me go offline and find out how I locate a sign interpreter, because she will also need the extradition hearing for Bryant.
Yes, Your Honor.
And then I believe Blunt is that a male or female?
Blunt, a male or female?
It said Blunt Dinkins.
It's a male.
Okay, so we'll do his extradition. That'll be the very last after the interpreters.
Yes, Your Honor.
Okay.
Also for Creasy, Deshaun, the one that's in the hospital,
Yes.
we still have the deputy that's on the route to them. He should be there in the next couple of minutes. Oh, he looks like he's logging on now.
Okay, so let me, by the time I log back on, because they want me to do him first, correct?
Yes, Your Honor.
Okay. Let me locate a sign interpreter, and then I will come back. I will come back on the record.
Yes, Your Honor.
Thank you.
Thank you.
Okay, thank you.
If someone could work on getting me the extradition paperwork for the third inmate, I would appreciate it.
Yes, Your Honor. We already have a deputy going down there to go work on that right now.
Okay, thank you.
Thank you, Your Honor.
Okay, Deputy, I'm ready to resume. So with respect to Ms. Bryan, I'm gonna have to continue her because my judicial assistant just told me is that we have to actually schedule that to have someone appear on Zoom. And so their services are not available on the weekend. So I'm gonna continue Ms. Bryan first appearance until Monday.
Yes, Your Honor.
So I'll issue an order to that at the conclusion of today's hearing.
Yes, Your Honor.
Yeah, Lisa.
Okay, are we ready for Mr. Is it Crazy?
Okay, thank you.
Hey, Judge, I'm trying to talk to the doctor right now. I'll let you know in just a second.
Okay, thank you.
They're checking his vitals.
Okay.
Hey, Judge, he's ready.
Okay, great.
Okay.
How you doing, Judge?
Fine, how are you, sir?
Not good.
Well, I'm sorry to hear that. Well, my name is Judge Tamika West, and I am a judge in Clayton County Magistrate Court. I am required to give you your first appearance today. So first, I will need to swear you in, and then I will give you your statement of rights.
All right.
Okay? Is it, do you have trouble raising your right hand?
No, ma'am.
Is there any way you can raise? Okay, there we go. Okay. Do you swear and affirm that the information that you provide to this court today, as well as the information you provide with respect to court-appointed counsel, will be true? You got to keep your hand raised the whole time if possible. Okay. Okay, thank you.
Yes, ma'am.
Do you swear and affirm that that information will be true and accurate to the best of your knowledge?
Yes, ma'am.
Okay, thank you. You can let down your hand. Okay, so let me give you your statement of rights with respect to your first appearance. Do you understand what a first appearance is?
Yes, ma'am.
Okay, the purpose of a first appearance is to notify you of the charges as well as determine if we're going to be able to set bail for you today. You understand that?
Yes, ma'am.
Okay, now we are not here to try your case or take a plea today. You are simply here for the court to inform you of the charges against you, advise you of certain rights, set bail on those offenses for which the court is authorized to set bail, and to schedule a preliminary hearing to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during these proceedings can be used against you if your case goes to trial. You understand that?
Yes, ma'am.
You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. You have the right to indictment by the grand jury for most felonies or accusations for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to hear, see, and cross-examine witnesses who are called to testify against you. You have the right to compel the attendance of witnesses in your own behalf by subpoena. You have the right to testify and offer evidence in your own defense should you choose to do so. But should you choose not to do so, no presumption of your guilt may be raised. You also have the right to have an attorney represent you. If you qualify for a court-appointed attorney, we will appoint an attorney to represent you. Now, in some cases, you will be allowed to post what they call an unrestricted bond for your release from jail pending prosecution of your case, which may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond in cash together with any applicable fees to the sheriff's office, who will then hold it until your final court date, at which time the cash bond will be returned to the person who posted it on your behalf. If you use a commercial bonding company approved by the sheriff's office, someone will have to pay the company up to 15% of the total bond amount as their fee for their service. This fee will not be returned. You may also post bond using property if you have net equity in the property in an amount equal to 3 times the total amount of the bond. You may also have special conditions included on your bond that prohibit you from contacting certain people or going to or around certain places. This special condition will be provided to you on your bond order. You will also be prohibited from calling or having any contact with the alleged victim while you're in jail. Should you violate the bond order, your bond will be revoked and you will not be entitled to another bond while awaiting trial. An additional charge of aggravated stalking, influencing witnesses, or other charges as the law may provide could be brought against you if you violate the terms and conditions of your bond, for which you could be sentenced up to 10 years in prison and fined up to $20,000. If there will be a family member assisting you with posting bond, they will be provided with information of your bond amount after we have concluded the first appearance calendar today. If a family member is a victim on the warrant and there is a special condition that you're to have no contact with that family member, he or she will not be allowed to post bond. If you are charged with an offense that this court is not authorized to set bail, a bond hearing will be scheduled before a superior court judge and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bail. Your bond can be reconsidered after your probation officer has an opportunity to determine if they wish to file a warrant for violation of your probation, usually during your preliminary hearing. The purpose of a preliminary hearing is to determine if there is enough evidence or probable cause to justify keeping you detained until such time as your case goes to trial. If you're charged with a misdemeanor only, you will have the option of waiving your preliminary hearing. Waiving your preliminary hearing will not affect your right to post bond, your right to have an attorney appointed to represent you if you qualify for one, or your right to a jury trial. If you post bond, your preliminary hearing is automatically waived and you will be mailed a notice when to appear in state court for your arraignment. If you cannot make bond, you may waive your preliminary hearing and be taken before a state court judge, at which time, if you plead guilty, you will be sentenced. If you plead not guilty, a trial will be scheduled on your behalf. If you choose to have a preliminary hearing, the hearing will be scheduled for November the 30th, 2021 at 8:30 a.m. If you are charged with a felony, you will not have the option of waiving your preliminary hearing. Your preliminary hearing will be scheduled for November 18th, 2021 at 8:30 a.m. Okay, if you would please state your full name for the record.
Deshaun Leroy Creasy.
Mr. Creasy, you've been charged with 2 counts to include theft of services and obstruction of an officer. Your total bond amount is $3,500. Do you understand the charges as well as your bond amount?
I do.
You say no?
I do.
Oh, you do? Okay. Can you make bond?
35. What I say it was? 3,500.
Yes, $3,500.
Not a day.
Okay. As I indicated earlier, I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. since you've been charged with 2 misdemeanors. You understand that?
Yes, ma'am.
Okay, you understand that to be your first hearing date, Mr. Creasy?
Yes, ma'am.
Okay. Were you able to complete a request for court-appointed counsel?
No, ma'am.
Okay. Well, let me see do you mind if I ask you a few questions to see if you qualify for a court-appointed attorney?
Sure.
Okay. Do you currently have a job?
I don't.
And give me your street address.
4241 Hendricks Drive, Forest Park, Georgia.
And you have guys from another rotation, crappy off days. Now they're all qualified. They're all on the same shift.
Do you have any money or cash that is obtainable that you can obtain from any other source?
No, ma'am.
Do you own any real estate?
No, ma'am.
Do you rent or do you own?
Neither one.
Do you have a car or any other personal property?
No, ma'am.
Right.
Are you married?
No, ma'am.
Rotation's up.
Do you have any children?
No, ma'am.
Do you have a relative that can help you with the cost of your defense?
No, ma'am.
Half my off days, that's that. Get forced to work.
Have you made any effort to get an attorney?
No, ma'am.
Have you ever served in the United States military?
No, ma'am.
Okay, based on your responses, Mr. Creaser, you will qualify for a court-appointed counsel, so I will go ahead and approve that request. Do you have any questions?
No, ma'am.
Okay, thank you.
All right, Judge, is that it?
Yes, that will conclude his first appearance today. Thank you,
Yes,
Deputy.
ma'am. Yes, ma'am. Leave that.
Okay, if you would step to the camera and please state your full name for me.
Janicia Latrice Anderson.
Ms. Anderson, you've been charged with 1 count of battery. Your total bond amount is $5,000. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bonds?
Yes, ma'am.
If you can make bond, there will be special conditions included in your bond order. The first condition is you're to have no contact with an individual by the name of Tyree Fincher. Do you recognize that name?
Tyree Fincher. Yes, ma'am.
Okay, who's that?
My child's father.
Okay, because he's the alleged victim in the case, you're to have no contact, which means you must stay away, absolutely, directly, indirectly, by mail, by email, by social media, by telephone, by third person, from his home, his workplace, and any immediate family members of any witnesses with respect to Mr. Fincher. Do you understand that?
Yes, ma'am.
Also, because the alleged incident occurred at 6448 Highway 42, Clayton County, Georgia, you're not to return to those premises. Is that your primary residence?
No, ma'am. That was the gas station.
Okay, great. Okay. I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. If you can make bond, would you like to waive your preliminary hearing or keep it on the calendar?
Waive it.
Okay. And you also completed a request for court-appointed counsel, correct?
Yes, ma'am.
Okay. And your responses are not clear. I guess you have a blank line. Do you currently have a job?
No, ma'am.
Okay, based on your response, you will qualify for a court-appointed counsel. Do you have any questions for me?
No, ma'am.
Okay, thank you, Ms. Anderson. Okay, if you would please state your full name for the record.
Kiana Lachey Harris.
Ms. Harris, you've been charged with 4 offenses to include criminal trespass, obstruction or hindering an emergency telephone, obstruction of a law enforcement officer, and a second count of criminal trespass. Your total bond amount is $7,000. Do you understand the charges as well as your bond amount?
Yes.
Can you make bond?
Yes.
If you can make bond, there will be special conditions included on your bond order. The first condition is that you're to have no contact with an individual by the name of Kiara Clark because she's the alleged victim in the case. Do you recognize that that individual's name?
Yeah.
Okay, who's that?
My ex-partner.
Okay. You understand no contact means you must stay away, absolutely, directly, indirectly, by mail, by email, pager, social media, telephone, or third person from Ms. Clark's home, workplace, and immediate family members of any witnesses with respect to Ms. Clark. You understand that?
Yes.
Secondly, because the alleged incident occurred at 1101 Stanford Circle, Marlow Drive, 30260, you're not to return to those premises. Is that your primary residence?
No.
Okay. Do you have any personal property that you would need to retrieve at that residence?
No.
Okay. I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive your preliminary hearing or keep it on the calendar?
Wait.
And you also, did you complete a request for court-appointed counsel?
Yes.
Okay, based on your responses, you do qualify for a court-appointed attorney. Do you have any questions?
No, ma'am.
Okay, thank you.
Thank you.
Okay, please state your full name for the record.
Anissa Renee Keeley.
And spell your last name for me.
Keeley, Keeley.
Ms. Keeley, you've been charged with 4 offenses to include DUI less safe, open container of alcohol in violation of state law, improper lane change, and license not on you when stopped. Your total bond amount is $6,500. Do you understand the charges as well as your bond amount?
Yes, ma'am.
Okay, can you make bond?
Yes, ma'am.
Okay, if you can make bond, then you cannot violate any laws while out on bond. Do you understand that as a condition of your bond?
Yes, ma'am.
Okay. I'll schedule your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing or keep it on the calendar?
Waive it.
Okay. Did you complete a request for court-appointed counsel?
Yes.
Okay. Okay. You stated you do have a job, but you didn't include your monthly wages. What would you estimate that to be?
I'm not sure. I actually just started, so they didn't give me all the information about
Do you know what your pay rate is an hour?
$15 for right now. And then it goes up to 17.
And then how many hours would you be working a week?
8 hours, 8 or 9 hours
A week or a day?
a day. So probably like 40 hours a week.
Okay. Okay, so that's about $600 a week. And approximately $2,400 a month. So based on your response, you do qualify for a court-appointed attorney. Do you have any questions?
No, ma'am.
Thank you. Okay, please state your full name for the record for me, please.
Ms. Lenise Jeanette Richardson.
Ms. Richardson, you've been charged with 3 offenses to include violation of Georgia Controlled Substance Act, possession of marijuana less than an ounce, and obstruction of a law enforcement officer. Your total bond amount is $8,000. Do you understand the charges as well as your bond amount?
Yeah.
Can you make bond?
Yes, ma'am.
If you can make bond, you cannot violate any laws while out on bond. Do you understand that?
Yes, ma'am.
I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. Do you understand that is your first hearing date?
Yes, ma'am.
And did you complete the request for a court-appointed counsel?
Yes.
So it appears you do have a job and you estimate your monthly wages to be, is it 200 or 2,000?
2,000.
Okay. Based on your response, you would qualify for a court-appointed attorney, so I will approve your request. Do you have any questions?
No, ma'am.
Okay. Thank you. Okay. Please state your full name for the record.
Rashida Gentry Roberts.
Okay, spell that for me.
Which one? Run first name?
Both, yeah, your first and last name.
Reshita. Roberts, Roberts.
Okay. And I got Rashida. Is that Reshita?
Yeah.
Okay. Ms. Roberts, you've been charged with 1 count of aggravated assault. Your total bond amount is $20,000. Do you understand the charge as well as the bond amount?
Yeah.
Can you make bond?
Yeah. I think.
Okay. Well, since you're unsure, okay, no problem. I'll put. If you can make bond, there will be a special condition included in your bond order that you're to have no contact with an individual by the name of Cameron Sims. Do you recognize that name? Okay, who's that? That's fine. What? Okay. Because Ms. Sims, is it Mr. or Ms.? Him? Yeah, that's him. Okay, Mr. Sims? Because Mr. Sims is the alleged victim in the case, you're to have no contact, which means you must stay away, absolutely, directly, indirectly, by mail, by email, by pager, telephone, or third person from Mr. Sims' home, workplace, and immediate family members of any witnesses with respect to Mr. Sims. Do you understand that? Yeah. Also, it appears the alleged incident occurred at 7002 Baltimore Court, Jonesboro, Georgia 30236. Is that your primary residence? No. Okay, because the alleged incident occurred there, I am going to include a provision that you're not to return to that location while you're out on bond. Okay. You also cannot violate any laws while out on bond as a condition of your bond, as a condition of your release. You understand that? Okay. I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. So that will be your first hearing date. You understand that? Yeah. Yes, ma'am. Sorry. And you completed a request for court-appointed counsel? I did. Ms. Roberts? Yes, ma'am, I did. Okay. And your responses on the form, so you're currently unemployed? Mm-hmm. Yes, ma'am. Okay. Based on your response, then you do qualify for a court-appointed attorney. Do you have any questions? No, I don't. Okay. Thank you. Okay. Please state your full name for the record. Spell your first and last name for me.
Christy Scott.
Spell it.
Christy. Scott, Scott.
Okay. Ms. Scott, you've been charged with 2 offenses, to include a false report of a crime and unlawful conduct during a 911 call. Your total bond amount is $2,000. Do you understand the charges as well as your bond amount?
Yes, ma'am.
Can you make bond?
Yes.
If you can make bond, you cannot violate any laws while out on bond as a condition of your release. You understand that? Yeah, you say yes?
Yes, ma'am.
Okay. Your first hearing date, preliminary hearing, is scheduled for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing or keep it on the calendar?
Keep it on the calendar.
You want to keep it on the calendar? Okay. And you completed a request for court-appointed counsel? Okay, you're currently unemployed, correct?
Okay. Yeah.
Okay, based on your response, you do qualify for a court-appointed attorney, so I will approve that request. Do you have any questions? Okay. Thank you, Ms. Scott. Please state your full name for the record. Okay, spell your first and last name for me.
CHUNUREA. And last name Spence, SPENCE.
Okay, thank you, Ms. Spence. You've been charged with one count of simple assault. Your total bond amount is $3,000. Do you understand the charge as well as your bond amount? Can you make bond? You say yes? Okay. If you can make bond, there will be special conditions included in your bond order. The first condition is you're to have no contact with an individual by the name of Reese Norfolk. Do you recognize that name? Who's that?
My ex-coworker.
Okay. Because she's the alleged victim in the case, you're to have no contact, which means you must stay away. Absolutely, directly, indirectly, by mail, by email, by pager, by telephone, or third person from the person's home, workplace, and immediate family members of any witness with respect to Ms. Norfolk. Do you understand that?
Yeah.
It also appears that the alleged incident occurred at 2529 Old Anvil Block Road, Ellenwood, Georgia, 30294. Is that your primary residence?
No, ma'am, that's my job.
Okay. Are you still employed there?
But he is not.
I'm sorry, I didn't hear you.
Yes, ma'am, but he is not.
Okay. You do understand if Ms. Norfolk still is employed there, that you will have to make provisions not to be in contact with her. You understand that?
Yes, ma'am.
You do understand? Okay. Also, I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing or leave it on the calendar? You want to waive it? Okay. And did you complete a request for court-appointed counsel?
Okay.
You did not? Okay. Do you not need an attorney?
No, ma'am.
Okay. So you're going to hire your own attorney?
Oh, well, yes, I need one from you guys. Yes, it's fine.
Well, did you complete a request for court-appointed counsel? Okay, why not?
I wasn't able to do anything, honestly. I've been in the holding cell for like 13 hours.
Well, you would have got the form from the deputies. You didn't get a form from the...
Yes, I did fill out the paper. I'm sorry, I didn't know it was. I'm sorry.
Okay, you did complete one? I can locate them. I don't see one. Let's see. Okay, I see it. Okay, I see it here. Okay. Okay, based on your response, you do qualify for court-appointed counsel. So I will approve that request. Do you have any questions?
No, ma'am.
Thank you, Ms. Spence. Okay. If the first male inmate will step to the camera and please state your full name for me.
State your full name. Step up to the camera, don't worry, I'll fix it.
Okay, give me your full name again.
Brian Anderson.
Okay, Mr. Anderson, you've been charged with one count of battery family violence. Your total bond amount is $5,000. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
I'll try. I have to make a phone call to you.
Okay. If you can make bond, there will be special conditions included in your bond order. The first condition is you're to have no contact with an individual by the name of Candace Starr. Do you recognize that name?
Yes, ma'am.
Who's that?
That's my girlfriend.
Okay. You're to have no contact, which means you must stay away. Absolutely. Directly, indirectly, by mail, by email, by pager, by social media, by telephone, or third persons from Ms. Starr's home, her workplace, and any immediate family members of any witness with respect to Ms. Starr. You understand that? Secondly, because the alleged incident occurred at 8515 Pine Lane Drive, Apartment A, Jonesboro, Georgia, 30238, you're not to return to those premises. Is that your primary residence?
No, ma'am.
Okay. I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Do you understand that is your first hearing date?
Yes, ma'am.
And you did complete a request for a court-appointed counsel. Based on my review, you do qualify. Well, you put you're employed, but you didn't give me a monthly range for your income. Can you give me a monthly range?
Say 2,000.
2,000 a month? Okay. Okay, based on your response, you would qualify for a court-appointed attorney. So I'll go ahead and approve your application. Do you have any questions?
No, ma'am.
Okay. Thank you, Mr. Anderson.
Look up, let me know your name.
Okay, I didn't hear you, sir. Please state your full name.
Tyrone Barker.
Spell it for me.
Barker.
Barker.
Yes, ma'am.
Okay. Mr. Barker, you've been charged with 2 offenses to include driving no tail lights and driving on a suspended or revoked license. Your total bond amount is $2,000. Do you understand the bond amount as well as the charges?
Yes, ma'am.
Okay. Can you make bond?
Yeah, I should be able to tell that. Just make a phone call.
Okay. If you can make bond, then you cannot violate any laws while out on bond as a condition of your release. You understand that?
Yes, ma'am.
I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing or keep it on the calendar?
Yeah, you can wait.
And did you complete a request for court-appointed counsel?
The paperwork, yes, ma'am. I don't think I put a monthly income on there. It's about 2,000.
You said about 2,000?
Yes, ma'am.
Okay. Okay. Based on your response, you will qualify for a court-appointed counsel, so I will go ahead and approve your application. Do you have any questions?
My bond is 2,000. So how much?
Your total bond amount is $2,500 for the tail light violation and $1,500 for driving on a revoked or suspended license. So your total amount is $2,000.
Okay. Okay.
Any other questions?
No, ma'am.
Okay, thank you. Okay. Please state your full name. Okay. Mr. Barrett, you've been charged with 1 count of battery. Your total bond amount is $4,000. I'm sorry, Deputy, if you could move the camera. Yeah, you could have a seat, sir. You could have a seat. Okay. Okay. Again, you've been charged with 1 count of battery. Your total bond amount is $4,000. Do you understand the charge as well as your bond amount?
Yes, I understand.
Can you make bond?
Yes, I understand.
If you can make bond, there will be special conditions included in your bond order. The first condition is you're to have no contact with an individual by the name of Neil Sinclair Curtsy. Do you recognize that name?
Not really. But what I want to say about that situation.
Okay, well, no, ask my question, then I'll allow you to ask questions.
Go ahead now.
Okay, you don't recognize that individual?
Yeah,
name?
Okay,
well, that's the alleged victim in the case. So no contact means you must stay away, absolutely, directly, indirectly, by mail, by email, by pager, by social media, by telephone, by third person, or from Ms. Curtsy's home, workplace, and immediate family members of any witnesses. Do you understand that as a condition of your release?
Yes, ma'am.
Secondly, let me finish, sir. I'll allow you to ask question when I finish. Secondly, you're not to return to the premises located at 4665 Ferris Circle, Forestport Drive, 30297. Is that your primary residence?
Yes, ma'am.
Okay, let me finish, sir. If that's your primary residence, you will have to make arrangement. Is it Ms. Kersey or you that's renting or owning?
It's the Airbnb. I've been there for 7 months.
Okay. Well, because the alleged incident occurred there, you're not to return to those premises while you're out on bond. Okay. Now, let me finish.
Yeah.
Thirdly, do you have any personal belongings at that location?
Yes, I have a lot of my belongings there.
Okay. Well, if you do, I will include as a condition of your bond order that you can schedule an appointment with the sheriff office or Clayton County to accompany you to that location to retrieve any undisputed personal property. You will have to make this appointment with the sheriff office within 10 days of your release. You understand that?
Yes, sir.
Also, as a condition of your bond, you're not to violate any laws while out on bond.
Yes, ma'am.
I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing or keep it on the calendar?
Yes, ma'am. Wait.
Okay, I'll take any questions you have, sir, with respect to your charges.
My charges that are brought against me, the people lied on me. 3 people jumped me.
Okay, sir. Now remember when we began, I said you have the right to remain silent and anything you say can be used against you. You understand that?
Yes, ma'am.
So I want to remind you of your right to remain silent. Okay? I'm not finished. I have one more question, Deputy. With respect to his request for court-appointed counsel.
Yes.
Okay. Based on your response, you would qualify for a court-appointed attorney. Do you have any other questions?
No, ma'am.
Okay, thank you.
This is time to get information, not for you to give statements.
Okay, please state your full name for me, sir. And spell that for me. Okay. Okay. Deputies, I thought we were doing his, he's entitled to an extradition here. I thought we were doing him last. We're doing all extraditions last.
Give me last. Okay, let's do that.
Okay, so please state your full name for the record.
Devontae Brantley,
Spell your last name.
Brantley.
Okay. You've been charged with 7 offenses to include use or possession of drug-related objects, possession of marijuana less than an ounce, criminal use of an altered firearm, speeding, obstruction or hindrance of a license plate, defective equipment, and an open container in violation of Georgia law. Your total bond amount is $9,000. Do you understand the charges as well as your bond amount?
Yes, ma'am.
Can you make bond?
Yes, ma'am. Yeah.
I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m.
I'm probably gonna make bond before that, but I'm gonna waive.
Well, since it's a felony, you can't waive it, sir. You have a felony with respect to the criminal use of the altered firearm. So one of those charges is a felony. You understand that?
No, I'm buying that.
Okay. So you understand that to be your first hearing date, November the 18th.
Most definitely, yes, ma'am.
Okay. And you understand you're required to appear?
Yes, ma'am.
Okay. And I have your court-appointed counsel form that you completed. Do you recall completing that, sir?
Yes, ma'am. You say, I gotta go to court even if I make bond for the 18th? Even if I bond up before then?
Yes, because you have one felony offense, so you have to appear before Superior Court judge to for your preliminary hearing to determine if it's enough evidence to bound your case over. You understand that?
I can still bond out though?
Yes. Yes, I am. Your bond amount though is $9,000, but you can still bond out.
Okay.
Understand that?
Yes, ma'am.
Okay. And then you do qualify for a court-appointed attorney, so I will approve your application. Do you have any other questions?
No, ma'am.
Okay. Thank you, sir.
Yeah, no, put your mask up first. Yeah, no, we'll keep that close.
Okay. Please state your full name.
Tony over here.
Yeah, going back. Go ahead, gentlemen. Hands behind your back, gentlemen.
And is Antonio Terrell Harris correct? Okay. Mr. Harris, you've been charged with one count of criminal trespass. Your total bond amount is $2,000. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
No.
If you can make bond, there will be special conditions included in your bond order. The first condition is you're to have no contact with an individual by the name of Tempa Larethan. Do you recognize that name?
Terrion.
Terrion, yes.
No.
Who's that?
My brother.
You say your brother? Okay. Because he's the alleged victim indicates you're to have no contact, which means you must stay away. Absolutely, directly, indirectly, by mail, by email, by pager, by telephone, or third persons from the person's home, workplace, and immediate family members of any witnesses. You understand that?
Yeah, no.
Secondly, because the alleged incident occurred at 3205 Poplar Point Drive, Atlanta, Georgia, you're to not to return to those premises. Is that your primary residence?
Yes, no.
Okay. I will, is that, do you live there with the alleged victim, your brother?
My mom.
You live there with your mom?
My brother don't stay there.
I'm sorry, I didn't hear you.
My brother don't stay there.
Okay, your brother doesn't stay. Where does your brother stay?
He got his own place.
Where?
He got his own place.
Okay. Okay, well, based on that, if you understand you're under oath with respect to that statement, sir?
Yes, ma'am.
Okay, well, if your brother doesn't live there, I won't preclude you from, I will allow you to return to those premises. Okay?
Okay.
You say you live there with your mom?
Yes, ma'am.
Okay. I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing and keep it on the calendar?
What is the difference? Did you explain?
Well, if you waive it, if you bond out, then you automatically waive the preliminary hearing. The purpose of the preliminary hearing is to determine whether or not there's sufficient evidence to continue to detain you in jail. But if you bond it out, it's no reason for the hearing. You understand that? So if you know you're going to make bond, you can waive it. If you're unsure, I will leave it on the calendar.
I'm gonna make bond.
Okay. Do you want to waive it or do you want me to leave it on the calendar? Okay. Okay. And did you complete a request for court-appointed counsel?
Yes, ma'am.
Okay. And based on, you're currently unemployed, is that correct?
Yes, ma'am.
Okay, based on your response, you do qualify for a court-appointed attorney. So I will approve your application. Do you have any questions?
Oh, how long would I have to take to until I
until I got a bond out? Like, unless I'm gonna just do the full.
No, as soon as I complete the first appearance calendar today, and then send over the bond orders to the jail, then you can make arrangements to post bond.
I can bond. Can I bond out now?
At the once the bond order is sent to the jail, you can begin to make arrangements. So I'll send that over today.
All right.
Okay. Any other questions?
No.
Okay. Thank you, sir. Okay. Please state your full name.
Henry C. Holder.
Mr. Holder, you've been charged with 2 offenses to include possession of a firearm by a felon and violation of Georgia Controlled Substance Act. Your total bond amount is $17,000. Do you understand the charges as well as your bond amount?
Yes, ma'am.
Can you make bond?
Yes, ma'am.
I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. Do you understand that to be your first hearing date?
Yes, ma'am.
And you completed a request for court-appointed counsel, correct, Mr. Holder?
I got a lawyer.
You have a lawyer? So you don't, let me see here.
I haven't got in contact with him yet because I haven't been able to use the phone, but as soon as I get in contact with him, I'll be okay.
Okay. Well, since you completed the court-appointed counsel form, I'm going to go ahead based on your response. You do qualify for a court-appointed attorney. And then if you don't need one, then that's fine. Since you completed the form, I would rather approve it if you're eligible.
Gotcha.
Okay. Any questions?
No, ma'am.
Thank you, sir.
Thank you.
Okay, please state your full name, sir.
Tarius Hope.
Mr. Hope, you charged with 1 count of battery. Your total bond amount is $6,000. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
Yes.
I've scheduled your preliminary hearing for November the 30th, 2021. Would you like to waive the preliminary hearing and keep it on the calendar?
Okay, if I waive, will I go to court faster?
No, if you bond out, it's automatically waived. So if you can make bond, then it's automatically waived, because the purpose of the hearing is to determine whether or not there's enough evidence to continue to have you in jail. But if you've already bonded out, it's no reason to have that hearing.
Okay, but what I was asking, like, if I waive it, will I go to court faster?
I can't determine that.
Okay.
If you're unsure, I would just leave it on the calendar. If you bond out, it's automatically waived.
All right, let me go on the calendar.
Okay. If you can bond out, there will be special conditions included on your bond order. The first condition is you're to have no contact with an individual by the name of Tarius Hope. Do you recognize that name?
That's me.
Okay. Let's see. It says here, I'm sorry, the alleged victim name is Miss Holden. Is it Holden? Do you recognize that name?
Yes.
Okay, who's that?
We stayed at a room house, and she was a friend of mine. And we had a couple of drinks. They stole my food, so we just I don't really know how that.
Okay. The reason why I asked, because she's the alleged victim in the case. So that means you must have no contact. You must stay away absolutely, directly, indirectly, by mail, by email, by pager, by social media, by telephone, or third person from the person's home, workplace, and immediate family members of any witnesses. You understand that?
Yes.
Secondly, because the alleged incident occurred at 1485 Sunset Way, Morrow, Georgia, 30260, you're not to return to those premises. Do you understand that?
Yes.
Okay. Do you have any personal belongings at that location?
Yes.
Okay. If you do, I will include a provision in your bond order that you can make an appointment with the sheriff of Clayton County to accompany you to that location to retrieve any undisputed personal property. However, you must make this appointment within 10 days of your release. You understand that? Okay, and did you complete a request for court-appointed counsel?
Yes.
Okay, based on your responses, you would qualify for a court-appointed attorney. So I am going to approve your application. Do you have any questions?
No.
Okay. Thank you. Please state your full name for the record.
Jordan Ingram.
Mr. Ingram, you've been charged with 4 offenses to include no tail lights, driving with no insurance, driving a motor vehicle with invalid registration, as well as obstruction of a law enforcement officer. Your total bond amount is $3,500. Do you understand the charges as well as your bond?
Yes, I do.
Can you make bond?
Yes.
Your preliminary hearing is scheduled for November the 30th, 2021 at 8:30 a.m. Would you like to waive your preliminary hearing or keep it on the calendar?
I'll waive.
Okay. And you completed a request for court-appointed counsel?
Yes. Yes, ma'am.
Okay. And what's your monthly income? I don't understand the response here.
2,500, 3,000 a month.
Okay. Okay, based on your response, sir, you would qualify for a court-appointed attorney, so I will go ahead and approve your request. Do you have any questions?
I need the name and badge number of the officer that arrested me. That's on the paperwork. I've been told that. That's on the paperwork.
Okay, your attorney will be entitled to that information upon your release. Okay. Any other questions? Okay, thank you, sir. Please state your full name.
Jones.
Okay, is that Dante Lamar Jones? I'm sorry.
Yes, ma'am.
Okay. Mr. Jones, you've been charged with 2 offenses to include arson in the first degree and interference with government property. Based on the nature of your offenses, I'm denying bond for you today. Do you understand the charge as well as the no bond?
Yes, ma'am.
I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. And did you complete a request for court-appointed counsel? Okay, based on your response, you would qualify for a court-appointed counsel, so I will approve your request. Also, I'm required to inform you that your bond hearing will be scheduled for December 3rd, 2021. Do you have any questions?
No, ma'am.
Thank you. Okay, please state your full name for me.
Howard Lacey.
Mr. Lacey, you've been charged with 3 offenses to include armed robbery, murder, and concealing the death of an individual. Based on the nature of your offenses, I'm not authorized to set bail for you today. Do you understand the charges as well as your no bond?
Yes, ma'am.
I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. And then your bond hearing will be scheduled for December 3rd, 2021. Do you understand those two different hearing dates, sir?
No.
Okay. Did you complete a request for court appointed counsel?
No, ma'am.
I do have an application here with, I thought this is, it appears that was completed by you. You live at 6745 Sunset Hills Boulevard.
Yes, ma'am.
Okay. And do you recall completing the application for court appointed counsel?
I think so.
I didn't hear you, sir.
Yes, ma'am.
Okay. Okay, based on your responses on the application, so you will qualify for a court appointed attorney. So I will approve that. Do you have any questions?
No.
Okay, thank you. Please state your full name. I'm sorry, having trouble hearing you, sir.
Yaris Norfolk.
Deputies, can we take them in alphabetical order? Because I still haven't done Kilgraph and Barrier. Are they no longer available?
What's the name? Margot?
George Adair Kilgraph?
Kilgraph. They everybody on there? What's the other one?
And Moyer, Crystal Ann Moyer.
Crystal Ann Moyer. Oh, that's the one that needs a Spanish interpreter, Your Honor.
No, I thought that was Bryant.
Bryant was the one that needed the sign language interpreter.
Okay. So Crystal Ann, we should have did her with the females. Is she still available? It says loans. Is she still available? Okay, I just want to make sure she was okay. She needs an interpreter.
Yes, Your Honor.
I wasn't aware of that. Okay, I'll have to get one on. We should have did her after I concluded the females. I wasn't aware she needed an interpreter. Okay, I'll have to get one on the phone. Let me finish the males. And then what about Kilgraph?
What is it? Come on.
Okay, state your full name for the record and spell it for me, sir.
George Kilgaris.
Okay, spell your last name.
Pilgaris.
You've been charged with 5 offenses to include kidnapping, robbery, violation of Georgia Controlled Substance Act, trafficking, and obstruction of a law officer. Based on the nature of your offenses, sir, I'm not authorized to set bail for you today. Do you understand the charges as well as the bond amount?
Yes, ma'am.
I'm sorry, no bond. You understand the no bond, sir? Okay. I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. And then your bond hearing is scheduled for December 3rd, 2021. You understand those as 2 different hearing dates?
Yes, ma'am.
Did you complete a request for court appointed counsel?
Yes, ma'am.
Are you currently employed, sir?
No, ma'am. No.
Okay, based on your response, you do qualify for a court-appointed attorney. So I will approve your application. Do you have any questions?
No, ma'am.
Okay, thank you.
Right here.
Okay, I'll take Mr. Norfolk now. Okay. Give me your full name, Mr. Norfolk.
Yaris Norfolk.
Okay. You've been charged with 4 offenses to include 2 counts of aggravated assault with a deadly weapon, reckless conduct, and possession of a firearm weapon during a crime. Your total bond amount is $58,000. Do you understand the charges as well as your bond amount?
Yes, ma'am, I do.
Can you make bond?
I'll try.
I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. Do you understand that is your first hearing date?
Yes, ma'am.
Did you complete a request for court-appointed counsel?
Yes, I did.
No.
I'm having trouble understanding your responses on the application. You said are you currently employed or not?
As of today, I'm not.
Okay, no. So it says how much you earn per week. You says something about earnings 3,500 to 4,000. What do you mean by that?
That's when I was working.
Okay, but you're currently unemployed.
Yes, ma'am.
Okay.
Here, yes.
Okay, based on that response, I will approve the request for court-appointed counsel. Do you have any questions?
No, ma'am, and thank you.
Thank you. Please state your full name.
Check Sacco.
Mr. Sacco, you've been charged with 2 offenses to include DUI, alcohol less safe, and illegal parking in the handicap zone. Your total bond amount is $8,500. Do you understand the charges as well as your bond amount?
Yes, ma'am.
You may bond.
I'll try, ma'am. You said 85?
8,500, yes.
I'll try. I just have to make some phone calls.
Okay, no problem. I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing or keep it on the calendar? If you're unsure about whether or not you can make bond, I would recommend you keep it on the calendar.
I would like to waive it.
You're gonna waive it?
Yes, ma'am.
Okay. Did you complete a request for court-appointed counsel?
Yes, it did.
Okay, based on your response, sir, you do qualify for a court-appointed attorney based on the responses on your application. So I will approve your request. Do you have any questions?
No, ma'am.
Thank you. Please state your full name.
Cameron Sims.
Mr. Sims, correct?
Yes, ma'am.
You've been charged with 2 offenses to include battery and cruelty to children. 3rd degree. Your total bond amount is $8,000. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
I can try.
I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing or keep it on the calendar? If you're unsure about waiving, making bond, I will leave it on the calendar.
I'll leave it on camera.
Okay. If you can make bond, there will be certain conditions included in the bond order. The first condition is you to have no contact with an individual by the name of Kiana Travick. Do you recognize that name?
That's the mother of my kids.
Okay, because she's the alleged victim in the case, there's a no contact, which means you must stay away absolutely, directly, indirectly, by mail, by email, by pager, by telephone, or third persons from her home, her workplace, and any immediate family members of any witnesses. Do you understand that?
That's why.
Also, because the alleged incident occurred at 7002 Baltimore Court, Jonesboro, Georgia, you're not to return to those premises. Is that your primary residence?
Yes, ma'am.
Okay, if that's your primary residence, I will include as a condition in the bond order that you will be allowed to make an appointment with the sheriff of Clayton County to accompany you to that location to retrieve any undisputed personal property. This appointment must be made within 10 days of your release to retrieve any personal property at that location. You understand that? You also cannot violate any laws while out on bond as a condition of your release. You understand? Lastly, did you complete a request for court-appointed counsel?
Are you talking about the paper?
Yes, your application, yes.
Yes, ma'am.
Based on your response, you do qualify for court-appointed counsel. Your response is on the application. Therefore, I will approve the request. Do you have any questions?
No, ma'am.
Thank you, Mr. Sams. Please state your full name.
Oriental Thompson.
Okay, deputies, I didn't receive any paperwork for Mr. You said it's Thompson?
Yes, ma'am.
Thompson is not on.
Okay, deputies, I didn't receive any paperwork for Mr. Thompson. He's not on my list.
No, yes, ma'am. He did a form. Everything was faxed off.
No, I'm saying I didn't receive any paperwork from the jail on him.
Understood.
We're going to call over the judge. Go and have a sit down. Go sit down. Judge, we're going to call over there and have them pass it, email it to you, ma'am.
Yes, because he's not even on the list that they sent over.
All right, come on, sir.
So I would. I know he has a standard bond, set bond here, but I still need to get the warrant information.
Oh, the warrant information. Okay, I got it.
I need, and then I don't believe I saw any criminal history for Mr. Thompson. So I need both.
All right, Judge.
Okay, please state your full name.
Barry Daniel Weaver.
Mr. Weaver, you've been charged with 6 offenses to include pointing or aiming a gun or a pistol at another, simple assault, battery, possession of firearm by a convicted felon, violation of Georgia Controlled Substance Act, and possession of marijuana less than an ounce. Based on the nature of your offenses as well as your criminal history, I'm not authorized to set bail for you today, sir. Do you understand the charges as well as the no bail?
Do I understand the charges?
Yes, as well as the no bond.
I don't understand the no bond.
Okay, the no bond was, I'm not authorized to set bail for you if you're already on active probation. According to the records that I reviewed, you were sentenced to 5 years probation on or about May 3rd of 2018. You recall that? Are you on active probation, sir?
Yeah. Supposed to be off of it soon.
I know supposed to, but it's still active. 5 years from 2018, May of 2018, it would not have expired. You understand that?
Yes, ma'am.
Okay, so therefore, I'm not authorized to set bail. We have to give your probation officer an opportunity to appear to see if they're going to request a warrant. Okay? Okay, I've scheduled your preliminary hearing for November the 18th, 2021 at 8:30 a.m. And then your bond hearing will be December 3rd, 2021 at 8:30. You understand the two different hearing dates?
The 18th is the bond hearing.
Be the first hearing, which is that's just to determine if it's enough evidence to continue to detain you in jail. And then the second one, December 3rd, will be for the bond hearing. You understand that?
Yes, ma'am.
Okay. And I see here you did complete a request for court-appointed counsel. Based on your response here, you will qualify for a court-appointed attorney, so I will go ahead and approve that request. Do you have any questions?
No, ma'am.
Thank you, sir. Okay. Please state your full name for the record.
Kenneth O'Shea Willingham.
Mr. Willingham, you've been charged with 1 count of battery. Your total bond amount is $6,000. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
No, ma'am.
Okay. I've scheduled your preliminary hearing for November the 30th, 2021 at 8:30 a.m. You understand that? If you can make bond, there will be special conditions included in your bond order. The first condition is you're to have no contact with an individual by the name of Emmanuel Morgan. Do you recognize that name?
Yes, ma'am.
Okay, who's that?
That's my brother. He attacked me.
I understand. Remember I told you had the right to remain silent, sir? Okay. Since he is the alleged victim in the case, there's a no contact, which means you must stay away absolutely, directly, indirectly, by mail, by email, by pager, telephone, or third person from his home, his workplace, and immediate family members of any witnesses. You understand that?
Yes, ma'am.
Secondly, because the incident occurred at 3 Treasure Drive, Riverdale, Georgia, 30296, you're not to return to those premises while you're out on bond. Is that your primary residence?
Yes, ma'am.
Okay. If that is your primary residence, I will allow you to make an appointment with the sheriff's office to accompany you to that location to retrieve any undisputed personal property. However, you must do this within 10 days of your relief if you can make bond. You understand that?
Yes, ma'am.
Did you complete a request for court-appointed counsel?
Yes, ma'am.
Okay. Based on your responses on your application, sir, you would qualify for a court-appointed attorney. So I will go ahead and approve that request. Do you have any questions?
No, ma'am.
Okay, thank you.
Man, do you want to take care of those 2 fugitives?
Do either one of them need an interpreter?
No, man.
Okay, yes, let's do that.
Yeah, both of you. Come on.
I thought you guys was working on the paperwork for the third fugitive. What's the status of that?
We don't.
The third name.
The third, what was yes, it was
We have that paperwork, Your Honor.
okay.
Shabik.
Yeah. Is that individual ready to go?
Yes, Your Honor.
Okay, you have them available?
Yes, Your Honor.
Okay.
No, the middle.
Okay, is that you, sir?
Yes, ma'am.
Okay.
No.
And then who else do we have here? What's your name, sir? In the red. I'm sorry, I didn't hear you. Okay, okay. Thank you.
We don't have a third one. That's for the interpreter. He's an interpreter.
Can we do all 3 of these, or what about the third? The third
one was the one that needed the sign language interpreter.
Oh, okay. I thought you guys were getting me confused. I thought it was Brian that needed it. Oh, okay, because the sign language interpreter, we're gonna have to schedule that on a Monday to get it done. We have to find someone to not so they don't need a Spanish interpreter. They need a sign language.
The sign language one was yes. Let's say
They do need a Spanish interpreter.
They need both.
Yes, Your Honor. For today, we just need the Spanish interpreter, Your Honor.
Okay, you're confusing me. We talking about the one inmate, the one that we. Okay, that inmate is
just needs a sign language
only.
Yes, Your Honor.
So I thought you guys told me that Bryant needed a sign language, or does she only need a Spanish interpreter?
Bryant was the male. He's the one that.
No, Andra, Andrea Bryant. I had her down as needing a sign language interpreter, so that was wrong. Is it that she just needed an interpreter?
That was a male, Your Honor.
Okay, does he just need a Spanish interpreter?
No, he just needs the sign language. That's the same one that's on for the fugitives list.
Okay, we have two that needs a sign language interpreter, right?
No, one, Your Honor. One.
You just told me that Andrea Bryant needed a sign language.
Andrea Bryant is the same person that needed the sign language. It's the same person.
I understand that, but then you also just told me that Shabik needed a sign language.
No, that one was on the fugitive list.
I understand that. And I asked you, were they available to do the extradition? You said, no, they need a sign language interpreter.
I'm sorry, there's a bit of miscommunication there. I understood wrong.
I'm going to play back the tape, sir. I think I understood you.
I misunderstood you.
Am I the only one that heard him incorrect? Did he not just say this person needed a Spanish interpreter? I mean, a sign language interpreter?
No, I'm sorry, Your Honor. I misunderstood.
Okay, so again, let's try this again.
Yes, ma'am.
The inmate that I need to do the extradition for Shambika. Do they need a sign language interpreter?
No, Your Honor.
Okay. Do they need a Spanish interpreter?
No, Your Honor.
So are they available for their extradition hearing?
Yes, Your Honor.
Okay. And where's that individual?
Right here, Your Honor.
Okay. And then I have Andrea Bryant, and that individual needs a sign language, correct?
Your Honor, yes.
Okay. So we're going to have to continue that individual into Monday.
Yes, Your Honor. I already sent him back.
Okay. And then we have Blunt Dinkins, who also is available, correct?
Yes, Your Honor.
Okay. And then just to clarify who we have remaining, Mr. Bandos, he needed a Spanish interpreter, correct?
Yes.
Okay. And then Ms. Durat, Estella, she needed a sign language, correct?
No.
What's her name?
Spanish.
Spanish.
Yeah, Spanish interpreter, correct?
Yes, it's correct.
Okay. And then Ms. Moyer needed a Spanish interpreter, correct?
What's her name?
Moyer, Moyer.
Moyer is the one with the Spanish. He's Spanish, yes. She's the one that's sitting. She's a female that's still here.
So we have 3 that needs a Spanish interpreter, correct?
2, Your Honor.
I have 3. I have Banos, correct? Is that
Yes,
correct?
Yes.
And then we still have Estella Dure. Estella?
That's the second person. One male, one female, and Spanish.
Okay, and then what about Crystal Ann Moyer? I haven't done her first appearance. Crystal, her name is Crystal Ann. No, that's a separate inmate. Her name is Crystal Ann Moyer, Moyer.
It says bonded out. Or loaned out. Sorry, loaned out for Crystal Ann Moyer.
So what does that mean? I have paperwork for her. Is she not available?
No, Your Honor. She's unavailable. She's loaned out.
So what does that mean?
Either to another facility or to the hospital. I'm not sure which. You can find out for you.
Yeah, I need to find out because I would need to put it on the continuous order. So we're going to have to continue her. Do you know if she's going to be available tomorrow?
I'll find out now.
Okay. Okay. Let's see how I want to proceed. I think I would prefer to do each one just to make sure they're clear about their rights, deputies. I'm just going to do, even though it may take a little longer, I'm going to do each person's hearing separately.
Yes, Your Honor.
Okay, so let me do Blunt Dinkins first.
Blunt.
Okay.
Here's the paperwork.
So I apologize for the confusion, sir, and the delay. My name is Judge Tamika West, and I am a magistrate court judge here in Clayton County. This hearing is what is called an extradition hearing. All of the rights that I have advised everyone of early on also apply in your case, but your hearing is a little bit different from the other first appearances that have taken place today. You do not have charges pending against you in Clayton County. You have been brought to court today because you have charges pending against you in another state, and they're requesting that you return to that state to answer these charges. That's from the state of South Carolina. Apparently, the state of South Carolina alleges there is a warrant out for forgery. Are you in fact defendant Deshaun Blunt Dinkins?
Yes, ma'am.
Do you already have an attorney representing you in this matter?
I think so.
You think so? Okay. You are charged with being a fugitive from justice. Therefore, I'm not authorized to set bail for you today. Do you understand that?
Yes, ma'am.
This hearing is being conducted pursuant to Georgia law, Title 17, Chapter 13. As you have heard, it is alleged that you are charged with forgery, and there's an outstanding warrant in the state of South Carolina.
So that's the total charge, like forgery?
Yeah, the only thing I have on the warrant is that there was a charge of forgery, and I have the warrant number.
Yes, ma'am.
Okay. In South Carolina, it says that you knowingly stayed in the state of Georgia, knowing that you was wanted in Beaufort County by Beaufort County Sheriff Office in South Carolina for forgery. Okay, you understand that? You have the choice as to whether or not you wish to contest extradition or waive extradition and be returned to the other state without going through the formal extradition process. If you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the state of South Carolina. The court may consider allowing you to post bond, but is not required to do so. And as I indicated to you before, there is a no bond. As you are wanted by another jurisdiction, I'm not setting bond in your case at this time. If you do not wish to voluntarily return to the state of South Carolina, you may file a writ of habeas corpus to contest the extradition. The writ of habeas corpus can only contest four things. The first thing is whether the extradition documents are in order or on their face. The second ground is whether you are charged with a crime that actually exists in the demanding state of South Carolina. The third is whether you are the person named in the request for extradition. And fourth, whether you are in fact a fugitive from justice. You cannot contest the issue of your guilt or innocence in the state of Georgia. You are entitled to the advice of counsel in contesting your extradition or in deciding whether to waive extradition. If the state is unable to extradite you within 30 days, you may be committed to the county jail for an additional 60 days awaiting your extradition. If the extradition is not completed in 90 days, then you will be released. If you decide to voluntarily waive extradition and return to the state of South Carolina, the state of South Carolina will have up to 60 days to travel here to transport you back to the state of South Carolina. If they do not come to transport you back to the state of South Carolina for a period not to exceed 60 days, then you will be released. Do you have any questions about anything I just explained to you?
No.
Do you wish to contest extradition or waive extradition and voluntary return to the state of South Carolina to answer the charges against you?
Voluntarily return.
I'm sorry, I didn't hear you, sir.
I guess waive.
Okay. If you waive extradition, then you will need to, the deputy will give you your waiver forms to sign. You must sign those forms for us to complete the extradition process. Do you understand that?
I got a question.
Sure. What's your question?
Me waiving it, that means I'm saying like, yeah, y'all can come get me, right?
Yeah, you're voluntarily agreeing to go back and answer the charges in the state of South Carolina. You understand that? Okay. Would you still like to waive?
Yes, ma'am.
Okay. Any other questions?
And to do.
I'm sorry, your last question, sir?
Waiving it is the fastest thing to do, yeah.
Well, I just explained to you what your rights were. If you stand contested, then you can be committed up to the county jail up to 90 days.
Okay, I'm gonna waive it.
Okay, you gonna waive?
Yes, ma'am.
Okay, well, again, you'll need to get the waiver forms from the deputy and they'll have you sign them. Do you have any other questions?
No, ma'am.
Okay, thank you, sir. And sir, I'm going to butcher your name, so I'm going to have you state your full name for the record.
Chengedi Shepherd Chibiko.
Okay, please spell that for the record.
MUCHENGUETI, last name CHABIKWA.
Okay. As I explained earlier, sir, my name is Judge Tamika West, and I'm a magistrate court judge in Clayton County. This hearing is what is called your extradition hearing. All the rights that I've advised everyone of earlier in the day also apply in your case, but your hearing is a little bit different than the other first appearances that have taken place today. You do not have charges pending against you here in Clayton County, Georgia. You have been brought to court today because you have charges pending against you in another state, and they're requesting that you return to that state to answer these charges. Specifically, the state of Oklahoma has asked you to return to that state to answer for an outstanding warrant for fraud. Do you already have an attorney representing you in this matter?
Not at the moment.
The hearing is being conducted pursuant to Georgia law, Title 17, Chapter 13. As you have heard, it is alleged that you are charged with an outstanding warrant in the state of Oklahoma. You have a choice as to whether or not you wish to contest the extradition or to waive the extradition and be returned to the other state without going through the formal extradition process. If you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the other state. The court may consider allowing you to post bond, but the court is not required to allow you to post bond in your case. As you're warranted by the state of Oklahoma, I'm not setting bond in your case. You understand that, sir?
Yes, ma'am.
If you do not wish to voluntarily return to the state of Oklahoma, you may file a writ of habeas corpus to contest the extradition. The writ of habeas corpus can only contest four things. The first thing is whether the extradition documents are in order on their face. The second way is that whether you are charged with a crime that actually exists in the demanding state of Oklahoma. The third way is whether you are the person named in the request for extradition. And fourth, whether you are in fact a fugitive from justice. You cannot contest the issue of your guilt or innocence in the state of Georgia. You are entitled to the advice of counsel in contesting your extradition or in deciding whether to waive extradition. If the state is unable to extradite you within 30 days, you will be committed to the county jail for an additional period of 60 days awaiting your extradition. If the extradition is not completed in 90 days, then you will be released. If you decide to voluntarily waive your extradition and return to the state of Oklahoma, the state of Oklahoma will have up to 60 days to travel here to transport you back to the state of Oklahoma. If they do not come to transport you back to the state of Oklahoma for a period not to exceed 60 days, you will be released. Do you understand that?
Yes, Your Honor.
Do you have any questions regarding what I just explained to you?
No.
Do you wish to contest extradition or voluntarily waive extradition and return to the state of Oklahoma to answer the charges against you?
I wish to waive it.
Okay. If you wish to waive it, then you will need to obtain your waiver forms from the deputies sign all copies and return them to me to complete the extradition, voluntary extradition process. Do you understand that, sir?
Yes, Your Honor.
Okay, thank you.
Your Honor, Mr. Thompson paperwork should have been sent to you by now, at least about 5 or 10 minutes ago. The clerks were sending it over to you.
Okay, I'll look at it. I'll check, deputy, while I'm off the record. I'll need to get an interpreter on the phone. So in that process, before I come back on the record, I will see if I have paperwork for Thompson and go ahead and review it.
Yes,
as soon as I get the interpreter on the phone, I will come back on the record and conduct the first appearance for the remaining inmates.
Yes, ma'am.
Okay, I see a third one. I only have 2 left. Is the third one Mr. Thompson?
Yes, ma'am. The one in the back.
Okay, thank you.
Yes, ma'am.
Spanish interpreters. You're gonna get past that.
Both need Spanish, correct?
That's my meeting.
Okay, thank you.
That's my meeting.
Okay, we'll go in alphabetical order. I'm back on the record. I do have the Spanish interpreter on the phone. If the first inmate needing a Spanish interpreter would step in front of the camera and please state your full name.
Muy buenas tardes, yo soy su intérprete inglés-español el día de hoy en esta llamada. Comenzaremos por orden alfabético. Regresamos a grabar esta sesión. Por favor, la primera persona, adelántese y por favor afirme, diga por favor su nombre completo.
Jorge Alberto Baños Jackson.
Por favor, repita.
Jorge Alberto Baños Jackson.
Ma'am, I hear, but I don't understand him very clearly. I'm going to ask you to repeat and speak louder. Por favor, hable más alto, por favor. No se le escucha muy bien.
Jorge Alberto Baños Jackson.
Jorge Alberto Báñez García.
Jackson.
Iriarte.
Jackson.
Ugarte.
No, Jackson.
Jaxi.
Ajá, Jackson. Y-A-X-S-I.
Yaxi. Y-A-X-C-E.
Okay, sir, did you understand?
That was Jorge Alberto Yaxi. Báñez Yaxi.
Okay.
Yeah.
He has been charged with 2 offenses to include loitering or prowling and giving false name, address, and date of birth. His total bond amount is $2,500. Does he understand the charges as well as his bond amount?
Sorry, did you say watering?
Loitering, L-O-I-T-E-R-I-N-G.
Oh, loitering.
Yes.
De acuerdo, señor. Usted tiene 2 cargos. El primero, de acuerdo, tiene que ver con vagancia, de acuerdo, y con andar merodeando, proporcionar también una dirección falsa. A esto se le fija una fianza de $2,500. ¿Entiende usted el cargo y la fianza?
La dirección la di bien, lo que pasa es que yo llevo 2 o 3 semanas viviendo ahí y no me la sabía bien, pero mi mujer llegó ahí a decírselas bien. Yo estaba ahí en Forest Park, pero apenas llevo poco viviendo ahí en Jonesboro y no me la supe decir bien.
Well, the address was correct. Well, the thing is that I recently moved there. I moved barely 3 weeks ago, and I didn't know the address correctly. It's not that I gave a false address per se.
let him know that that's not my question was, did he understand the charges?
Señor, mi pregunta era si usted entendió los cargos.
¿Cómo?
La pregunta es si usted entendió los cargos.
Sí.
Yes.
Okay. Ask him if he can make bond.
¿Puede usted pagar la fianza?
¿Para cuándo?
When?
¿Para cuándo sería?
When would I need to do that?
At the conclusion of today's hearing, he will have the opportunity to make arrangements to make bail.
Al concluir la audiencia el día de hoy, tendrá usted la oportunidad de hacer los arreglos correspondientes para poder pagar su fianza.
El día de hoy. No sé si me podría dejar hacer una llamada. A ver.
Would it be possible for you to let me make a phone call?
Yes. At the conclusion of today's hearing, I will issue the bond order, allow him to see if he can bond out.
Al término de la audiencia, le voy a informar si puede usted salir bajo fianza. All right.
Secondly, I have scheduled his preliminary hearing for November the 30th, 2021 at 8:30 a.m.
En segundo lugar, tengo programada su audiencia preliminar para el 30 de noviembre a las 8:30 de la mañana.
30 de noviembre.
November the 30th?
Yes.
Sí.
¿Pero qué? ¿Ahorita saldría yo o no? Bueno.
Would I be released right now or?
Okay, he can be released on bond, but he still must appear in court for his first hearing scheduled for November the 30th, 2021.
Puede usted salir bajo fianza el día de hoy, pero aún así tiene que acudir a la corte a su su audiencia de primera comparecencia el 30 de noviembre del 2021 a las 8:30 de la mañana. Yes, fine.
If he is able to make bond, he's not to return to the premises located at 8436 Al Bond Drive, Jonesboro, Georgia, as a condition of his release.
Si es usted, si sale usted liberado bajo fianza el día de hoy, no puede usted regresar cerca de la dirección en el 8436 de Elborn Drive, en Jonesboro, Georgia. Esta es una condición para su liberación.
Sí, está bien.
Yes, that's fine.
Can you ask him if he needs a court-appointed attorney?
¿Necesita usted un abogado designado por la corte?
¿Cómo? Por si no lo entiendo.
I don't understand that.
Can you ask him if he needs an attorney appointed to represent him?
¿Necesita que le asignen a usted un abogado para representarlo?
¿Para el día de la corte?
¿Por court date?
Yes.
Sí.
¿Sería para el 30 de noviembre?
November the 30th?
Yes.
Sí.
Sí, está bien.
Yes, that's fine.
Ask him if I can ask him a few questions to determine if he qualifies for an attorney a court-appointed attorney.
¿Le puedo hacer algunas preguntas para determinar si califica usted para que le asignen un abogado designado por la corte?
Sí, está bien.
Yes, that's fine.
Does he have a job?
¿Tiene usted trabajo?
Sí.
Yes.
How much does he make a month? What is his monthly wages?
¿Cuál es su salario mensual?
Pues si trabajo la semana completa son 950.
If I work during the whole week, that would be $950.
Okay. Please let him know that unfortunately he does not qualify for a court-appointed attorney.
De acuerdo. Lamentablemente no califica usted para que la corte le designe un abogado.
No. Y entonces, ¿cómo tendría que pagarlo yo o cómo?
Then how would I pay that or what?
Let him know that it is based on his wages.
No, bueno, eso se basa en lo que usted gana, en su salario.
¿Cómo? No entiendo.
I don't understand.
The criteria for determining whether or not he is eligible for a court-appointed attorney is based on the amount of wages that he earns each month, and he's over the amount.
La decisión para que la corte le dé un abogado, el criterio es lo que usted gana al mes. Y usted gana más de lo que la corte, de lo que el criterio establece para poderle dar un abogado. No califica.
Entonces, ¿cómo? No lo entiendo ahí.
Por favor, repite.
No, es que no lo entiendo, así que no.
No, I don't understand.
Okay, well, let him know I've done the best job to explain it. Okay? And let him know that concludes his first appearance for today.
Sorry, that concludes what? Sorry, ma'am?
His hearing for today.
All right. Bueno, yo ya hice lo mejor para tratar de explicárselo. Con eso concluimos su audiencia el día de hoy.
Y disculpe, ¿y ahorita no podría hacer una llamada telefónica? Por favor.
Couldn't I make a phone call?
Yes, you can talk to the sheriff's office to ask if he can make a phone call. Tell him to have a nice day.
All right, you're gonna have a phone call in the jail. Come on, sir.
Hable con la oficina del sheriff del alguacil y pida su llamada telefónica. Que tenga buen día.
Sí, gracias. Bueno.
Okay. Please state your full name for the record.
Señor, por favor, su nombre completo para el registro.
Sí, Estela Duarte.
Estela Duarte.
He has been charged with 5 offenses to include driving with no insurance, driving unlicensed, open container in violation of state law, and violation of Georgia Controlled Substance Act. Does she understand the charges?
De acuerdo. A usted se le acusa de 5 delitos: manejar sin seguro, manejar sin licencia, manejar con un envase abierto, con un contenedor abierto y, bueno,
Sí, sí los entiendo, pero no, yo entiendo el de la licencia porque yo sé que no tengo licencia. El de la aseguranza, honestamente, yo no sabía que no cargaba la aseguranza. Yo pago mensual. Yo trabajo, pago mi carro y pago la aseguranza. Entonces, yo mensualmente mando el dinero de la aseguranza a la persona que la tiene bajo su nombre porque como al ser menor de 25 años, me sale demasiado cara. Y yo ignoraba que no tenía aseguranza. Y pues no pude saber de eso.
Un momento, por favor. I'm going to ask your customer to repeat. That's a lot of information, and I hear her very muffled. So just a second, ma'am.
Okay, and if you could ask her to speak louder.
Brief. Yes, as brief as possible. Señorita, ¿podría usted responder brevemente y hablar más alto? Casi no se le entiende.
Ok, perdón. Sí, le digo que sí acepto el cargo de no licencia porque yo sé que no cargo licencia para manejar. Eso es mi problema. El de la aseguranza, yo honestamente, yo pago mensual la aseguranza, no yo, sino que le mando el dinero a la persona que la tiene con su nombre y yo ignoraba que la persona no había pagado la aseguranza. Yo sé que la aseguranza se paga cada 4 de mes y pues honestamente no sabía y no me he podido comunicar con ella para preguntarle.
Well, regarding the license charge, yes, I accept that because I know that I don't have a driving license. As for the insurance, I pay my insurance every month, but I do it through a third person. I didn't know that that person hadn't made the payment. I make the payment every 4th of the month. I ignored, I didn't know that that person hadn't made the payment as yet.
Okay, my question, please let her know that today, the purpose of today's hearing is not to try her case, but just to inform her of the charges.
Bueno, señorita, el propósito de la audiencia el día de hoy no es averiguar sobre los motivos, sobre las causas de sus cargos, sino solamente informarle los cargos.
Please let her know that I'm setting her bill at $5,500.
Estoy fijando su fianza el día de hoy en $5,500.
Okay.
Her first hearing date is November the 30th, 2021 at 8:30 a.m.
Su primera audiencia su audiencia inicial es el 30 de noviembre a las 8:30 de la mañana.
Ok, perfecto. ¿Puedo pagar la fianza el día de ahora y presentarme el día de la audiencia ya con un abogado?
Can I pay my bond today and then show at the court on the appointed date with my lawyer?
Yes, as soon as I send over the order, she can make arrangements to bond out today.
Sí, por supuesto. En cuanto yo ordene que se hagan los arreglos, usted puede pagar su fianza y salir.
Ok, muchísimas gracias. Y quería preguntar si puedo si le puedo pedir al oficial hacer una llamada para poderle hablar a la persona que esté pendiente para que cheque para pagar. Simplemente eso.
Very well. Thank you very much. Question, can I ask for a phone call so I can get in touch with the person to be able to make the payment?
I have no authority to request that, but I can see if she qualifies for a court-appointed attorney, if she will allow me to ask her a question.
No tengo la autorización para solicitar esto. Lo que sí puedo hacer es determinar si califica usted para asignarle un abogado designado por la corte, si es que me permite hacerle un par de preguntas.
Sí, está bien.
Yes, that's fine.
What is her monthly take-home pay?
Bien, ¿cuánto lleva usted a casa al mes? ¿Cuál es su salario?
Por semana gano $500. Son como $2,000 por mes.
¿Me repite, por favor? Dos, gracias. Around $2,000, ma'am.
Please let her know that she does qualify for a court-appointed attorney, so I will approve her application.
Usted sí califique para el abogado asignado por la corte, entonces voy a aprobar su solicitud.
Ok, muchas gracias.
All right, thank you very much.
Please let her know. Please let her know that that concludes her hearing for today.
Con eso concluimos nuestra audiencia el día de hoy.
Ok, muchas gracias.
All right, thank you very much, ma'am.
Thank you, sir.
Don't you do the last one, though.
Anything else I can do for you?
Nope, that will do it.
Thank you for your services. Have a wonderful day. Bye-bye.
Thank you. Okay, deputies, I didn't have the criminal history for Mr. Thompson. I now have the warrant and the criminal history. I did send an email requesting it, so I'll need to check my email to see if I have it. So if you will stand by, I will check my email to see if I have it, and then I will come back on the record.
Yes, Judge.
Okay. Please state your full name for the record.
Oriental Thompson.
Mr. Thompson, you've been charged with 1 count of possession of possession of marijuana less than an ounce. Your total bond amount is $1,500. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
Yes, ma'am.
Your preliminary hearing is scheduled for November the 30th, 2021 at 8:30 a.m. Would you like to waive the preliminary hearing and keep it on the calendar?
Wait. Okay. And can I state something else? No,
not if it's not with respect to, not if you don't have a question about the charge or the bond amount.
Oh, never mind. No.
Okay. Also, did you complete a request for court-appointed counsel? Let's see here. Mr. Thompson, I do have it. Okay. Okay, based on your responses, sir, you do qualify for a court-appointed attorney, so I will approve your request. Do you have any questions?
No.
Not with respect to your guilt or innocence, just about the process or your charges. Do you have any questions, sir?
No, ma'am.
Okay.
No.
Thank you.
Your Honor, I'll have that information sent over to you immediately.
Okay, before we go off the record, Debbie, I don't know if you could help me with this, but we need to be more efficient tomorrow. The piecemealing me, the information is not going to work. So what can we do? Or who do you know who I need to talk to so I can get my information on time? Because I get up at 5 a.m. to start first appearance on time. So it's very disconcerting when I'm getting piecemealed information and it takes over 3 hours to do first appearance. That's not very efficient for either one of us.
I completely agree with you there, Your Honor. We just had a lot of situations that happened today, Your Honor. It was just, we all did the best we could.
Okay, can we approve upon that tomorrow?
Absolutely, we will. I'll be here early, Your Honor.
Okay, I appreciate it. Thank you.
You're welcome.
Okay. You'll get those waiver forms sent over to me in the next hour?
Yes, I'm going over there right now to send it over to you.
Okay, thank you.
You're welcome, Your Honor.
I'm logging off. Thank you.
Thank you, Your Honor. Take care.
All right, good morning. Can you all hear me?
Yes, Your Honor.
Yes, Your Honor.
All right, we're ready to proceed here this morning. Do you all have anyone that need the services of Ms. Tolles, our Spanish interpreter today?
I believe one of the males do, Your Honor.
All right, let's just do him first. Whomever that may be, if you could just bring him up. Good morning, Ms. Tolles. How you doing?
Good. I just want to let you know if you hear background noise, at my subdivision, they do the landscaping on Tuesdays, and so that's what the hum is in the background. I apologize for that.
Yes, ma'am, no problem. We'll make it happen.
Your Honor, the interpreter is going to be, I'm with the females today. That's going to be Deputy McKenna, and it's going to be inmate Perez Palacios.
Okay.
Yes, sir.
Yeah, let's do her so we can send Ms. Tolles about other business here. And if he's not on right now, can you radio him or get him or something?
Yes, Your Honor.
All right, Deputy Ricania. We're gonna do Miss Perez first, so that she can have Miss Tolles, Spanish interpreter.
Yes, Your Honor. Perez, señor, ven aquí. Aquí.
All right, Ms. Perez, good morning to you. Well, Ms. Tolles, you're on the oath all the time, so you're good.
Yes, sir.
This is Mr. Perez. Good morning. Good morning to you, sir.
Hola, señor Pérez. Buenos días. Good morning.
All right, this is the Clayton County Magistrate Court. Today is October 26, 2021. I'm Judge Knights presiding on your first appearance.
Estamos en la sala menor del Tribunal de Primera Instancia del Condado de Clayton. Hoy es el 26 de octubre de 2021. Yo soy el juez Knights que preside.
Sir, today I'm going to inform you of the charges that you have against you, your next court date, and appoint an attorney to represent you if you qualify.
Hoy le voy a informar de las acusaciones en su contra, le informo de su próxima audiencia judicial y le designaré un abogado de oficio si cumple los criterios para uno.
Sir, most importantly, I have constitutional rights that I wish to inform you of that never go away.
De suma importancia, hay algunos derechos constitucionales de los cuales le tengo que informar que nunca desaparecen.
Sir, the state has to prove these charges against you beyond a reasonable doubt.
Señor, el Estado tiene que probar estas acusaciones en su contra fuera de una duda razonable.
You have the right to a speedy and public trial by jury.
Tiene derecho a un juicio público y sin demora ante un jurado.
You have the right to see, hear, and cross-examine any witnesses that the state can call to testify against you at that trial.
Tiene derecho a ver, escuchar y contrainterrogar a cualquier testigo convocado por el Estado para declarar en su contra.
You have the right to subpoena witnesses on your own behalf.
Tiene derecho a citar testigos para que declaren a su favor.
And you have the right to testify if you choose to do so.
Y también tiene derecho de dar su propio testimonio si elige hacerlo.
If you choose not to testify, then the presumption of innocence or the presumption of guilt may be raised.
I'm sorry, Your Honor.
If you choose not to testify, the presumption of your guilt may be raised.
Si usted elige no dar testimonio, la presunción de su culpabilidad puede pasar.
However, you have that presumption of innocence until and unless the state can prove these charges against you beyond a reasonable doubt.
Sin embargo, usted se queda con la presunción de inocencia a no ser y a menos que el Estado pueda probar las acusaciones en su contra fuera de una duda razonable.
All right, sir, you have a next court date after today. If you remain in custody, and that court date would be December 6th at 8:30.
Bueno, señor, la próxima cita judicial que usted tendrá después del día de hoy, si sigue detenido, sería el 6 de diciembre a las 8:30 de la mañana.
That is your preliminary hearing. If you bond out of jail, that date goes away.
Esta audiencia sería la audiencia preliminar, pero si deposita fianza para salir de la cárcel, entonces esta audiencia se renuncia.
All right, you have the right to an attorney, sir. Did you complete an application for court-appointed counsel?
Señor, usted tiene derecho a un abogado. ¿Llenó la solicitud para el abogado de oficio, señor?
No, aún no.
The interpreter did not hear, Your Honor. Let me ask him again. ¿Cómo dice, señor? Perdón, no le escuché bien.
No, aún no.
No, not yet.
All right. What is your monthly income?
¿Cuáles son sus ingresos mensuales, señor?
Dependen del estado de trabajo, cerca de $2,000 por mes.
It depends on how the work is. It's $2,000 a month.
All right, sir. I will appoint an attorney to represent you. What is your phone number?
Voy a designar entonces un abogado para representarle, señor. ¿Cuál es su número de teléfono?
No tengo aún, también, es nuevo y no me lo sé, está mejor así que mis pertenencias.
I don't have it yet. It's a new one and I don't know it by heart.
All right. You're charged with theft by receiving stolen property. Your bond is $5,000, and you're charged with driving with license expired, and your bond is $1,000, and $6,000 is your total.
Entonces, las acusaciones que tiene son tenencia de bienes robados. La fianza para esta infracción son $5,000 y luego de manejar con licencia vencida, la fianza para esta infracción es $1,000. En total, la fianza es $6,000. Okay.
Thank you.
Thank you.
All right, sir. Do you have any questions?
Está bien, señor. ¿Alguna pregunta?
No, ninguna.
No, no questions.
All right, thank you.
Bueno,
All right, that will
gracias,
conclude
señor.
your first appearance.
Ok, queda concluido su audiencia inicial. Gracias.
All right, let's just make sure here, Deputy Ricania, no one else there needs a Spanish interpreter.
Yes, we need for one more, Martinez.
Oh, okay. I wish you had told me that before we went through all of this. Is there anyone else besides Martinez?
That'll be it for the mail side. My apologies, Your Honor. I was just running around trying to get people, and time just kind of got the best of me.
Okay. All right, let's get Martinez, please.
Martinez.
Mr. Martinez, good morning, sir.
Señor Martínez, buenos días.
Buenos días, señora.
Good morning.
Sir, did you hear everything that I just outlined to Mr. Perez Palacios?
Señor Martínez, ¿escuchó la información que yo le expliqué al señor Pérez Palacios?
Sí.
Yes.
All right. Well, all of those rights apply to you, sir. And,
Bueno, todos estos derechos también le corresponden a usted, señor.
sir, you are charged with driving under the influence of alcohol. Your bond is $5,000.
Se le acusa, señor, de manejar bajo los efectos de alcohol. La fianza para esa infracción son $5,000.
You're charged with striking a parked or fixed vehicle is $1,500.
También se le acusa de chocar un vehículo estacionado. And I'm sorry, Your Honor, what was the bond for that one?
$1,500.
Okay. La fianza para esa infracción son $1,500.
Well, it's actually 2 counts of that, and they're both $1,500 each.
Bueno, son 2 infracciones de manejar, de chocar un vehículo estacionado y son $1,500 cada uno.
En total, ¿cuánto es?
And how much is it in total?
It's $8,000 is the total.
Son $8,000 en total.
Y los tengo que pagar ahora para salir,
Do I have to pay it now to get out?
Yes, sir. You contact the bonding company, and you can pay that. If there are no holds on you, then you may be released.
Sí, señor. Puede comunicarse con una compañía de fianzas para pagar la fianza y puede hacerlo si no hay ninguna orden que lo retiene detenido.
All right, sir. Did you complete an application for court-appointed counsel?
Señor, ¿usted llenó la solicitud para el abogado de oficio?
Sí, pero nomás lo que alcancé a entender, lo que no entendí muy bien, lo dejé en blanco.
Yes, but only what I was able to understand on the form.
All right. Well, looks like you, I found your form.
Está bien, señor. Bueno, ya encontré su formulario.
Gracias.
And the only
Thank you.
did not answer 3 of the questions here.
Solamente no contestó 3 de las preguntas.
Okay. Sí, es que no le entendí.
Are you?
Okay, I didn't understand them.
Okay. I'll ask him now. Do you have anyone who can help you retain an attorney or hire an attorney?
Está bien, yo le pregunto ahora. ¿Tiene usted a alguien que podría ayudarle a contratar a un abogado o pagar a un abogado?
No, no tengo.
No, I don't.
All right. Were you in the military?
¿Sirvió como militar, señor?
No.
No.
All right. Well, you answer. Are you married?
¿Y es usted casado, señor?
Soy soltero.
I'm single.
Any children?
¿Hijos?
No tengo.
I don't have any.
All right, sir. I will appoint an attorney to represent you, sir.
Bueno, señor, le voy a nombrar un abogado de oficio.
Gracias.
Thank you.
All right, you're welcome. That will conclude your
nada.
first appearance today, sir.
Queda concluido entonces su audiencia inicial. Gracias, señor.
¿Puedo hacerle una pregunta?
I have a question.
Yes, sir.
Sí, señor.
En caso que no llegue yo a pagar la fianza así como es, ¿qué pasará conmigo? ¿Me van a detener más tiempo?
In case I'm unable to pay the bond as it stands, what would happen? Will I be detained for longer?
Yes, you will remain in custody. The date of December 7th is your preliminary hearing date.
Sí, señor. Usted seguirá detenido. La fecha de su audiencia preliminar sería el 7 de diciembre a las 8:30.
Bueno, está bien. Gracias.
All right. All right, then. Thank you.
Yes, sir. Thank you.
A usted, señor. Gracias.
Gracias.
All right, Ms. Toles, thank you for coming out and your patience this morning. We'll see you next time.
All right. See you next time. Thank you. Have a great
Thank
one.
you. You too. All right, Mr. Martinez, you're good. All right, let's do it with the females, if that's what we're doing.
Yes, sir.
All right. And the males, I guess. Get everyone. Females are going first today, Deputy Jackson.
Yes, sir. Yes, sir. We're ready.
Okay. All right, Deputy Ricania, there we go. All right. All right, good morning, everyone. Today is October 26, 2021. This is the Magistrate Court of Clayton County. I'm Judge Knights. I'm presiding this morning on the first appearance calendar. First appearance is me to inform you of what you're charged with, your bond amount, if you're entitled to bond, your next court date, which is your preliminary hearing date, and also to appoint an attorney to represent you if you so qualify. And most importantly, I will tell you about your constitutional rights that you have. Those rights never go away. No one can take them away from you. So you have the right to, or the presumption of innocence, and you have the right for the state to prove this charge or these charges against you beyond a reasonable doubt. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine any witnesses that the state can call to testify against you at that trial or at any proceeding related to this charge or these charges. You have the right to be represented by an attorney through every proceeding related to what you're here for. You have the right to have the state or to see, hear, and cross-examine any witnesses that the state may call to testify against you. You have the right to subpoena witnesses on your own behalf, and you have the right to testify if you choose to do so. If you do not choose to testify, your presumption of guilt may be raised. However, you still have that presumption of innocence until the state can prove this charge or these charges against you beyond a reasonable doubt. I want to let you know we're live streaming this on YouTube. Please resist the urge to tell me facts about your case. I'm not your lawyer. I can't give you legal advice, and I can't have a trial today. That's not why we're here. All those important facts that you want to tell me about your case or things you think that may help you, tell that to your lawyer. That's who needs to hear about it. Don't tell me, because if you tell me and it's something that will incriminate you, then the prosecutor, which is the district attorney or the solicitor general, can go back and review this YouTube recording, and you will be live here or replayed saying something that you thought may be helpful but may not be. So that's the caution I will give you. Besides that, I can't give you legal advice. That's for your lawyer to do. Your next court date is your preliminary hearing. Your preliminary hearing is December 6th if you're charged with the felony, December 7th if you're charged with all misdemeanors or at least one misdemeanor only. And if you do not get a bond, your bond hearing date is December 10th. All of those times are at 8:30, December 6th, 7th, and 10th, all at 8:30 a.m. Now, you're in magistrate court. This is the gateway court to state court or superior court. If you're charged with a misdemeanor, your case goes to state court. If you're charged with at least one felony, your case goes to superior court. But that is only after this matter goes to a preliminary hearing, or if you bond out of jail before preliminary hearing, you'll stand by in the mail for your arraignment date. Your preliminary hearing is the next court date. That is a probable cause or a prelim hearing. It means that the prosecutor must bring a law enforcement officer or detective, an investigator, whomever was involved with your arrest, and they will testify as to the things they did and the reason for your arrest. There has to be a valid, articulable reason for arrest. If there is a valid reason, that is known as probable cause. Your case goes to state court or superior court, respectively, if it's a misdemeanor or felony. If there's no valid probable cause, it's not an articulable, valid, real reason for your arrest, then your case or your charges go away. They're dismissed. Now, that is coming up December 6th or December 7th. If you bond out of jail, which you have every right to do and should do if you can, then that date goes away. You'll be on standby in the mail for your next court date, which will be your arraignment. Speak with your lawyer for more details about that. Also, if you don't qualify for court-appointed counsel, of course, you can hire a lawyer at any time if you choose to do so, or you can represent yourself at any time if you choose to do so. Some of you may not get a bond today. Well, not may not, will not. Some of you will not get a bond today. That is because you're in magistrate court. And magistrate court judges by law cannot give a bond on certain offenses. They're known as like the 7 deadly crimes. They're, for example, murder, rape, armed robbery, child molestation, or aggravated child molestation, aggravated sodomy. Those type of charges and some additional ones that I did not mention, you can't get a bond today. If you don't get a bond today, it doesn't mean you're not getting a bond. It means that you're not getting one today. Speak with your lawyer and see if your lawyer can contact the assistant district attorney that's assigned to handle your case, and go from there with getting a bond, or your bond hearing or your preliminary hearing will be times to address bond, if not before that. Also, some of you will have bond conditions. They're called special conditions. If I say don't go to 123 Main Street, you can't go there. Don't contact Joe Smith or Jane Smith, you can't contact Jane Smith or Joe Smith. Those are special conditions. Failure to comply can result in additional criminal charges like influencing a witness, aggravated stalking, and other charges. Keep that in mind. They're very serious. Once you bond out, can't contact the person. If there was any type of contact or threats, physical crime, person-to-person crime, then I will tell you a special condition. You can't reach out to that person directly, indirectly, social media, third party. Also, that person cannot post your bond. It has to be someone else. And that's for your safety, their safety, society's safety. That will be something, again, you can talk to your lawyer. It's not forever. It's for today, because it's first appearance, right? It's not a trial. All those things will be handled after today. I'm just informing you. I'm the informative judge today. After today, all your matters will be handled accordingly at the appropriate proceeding. All right, the bonding company, they decide the percentage of bond. I don't know. I don't work for the bonding company. I can't tell you what percentage you have to pay. That would be for the bonding company and you in your discussion with them. If you're posting a property bond or someone else is, generally, I can tell you there can be up to 3% of the bond that's needed or equity of the bond in the property. So the equity in the property has to be at least 3 times the bond amount. So for example, the bond is 1,000, the equity must be at least 3,000. So that's the extent of my knowledge on how the bonding company will relate to you. All the other questions you have are for them. If I appoint an attorney to represent you, that attorney will make contact with you in some way. I can't tell you when or who it will be because that would be for the public defender's office or Lister and Holt and Dennis. If you're charged with a misdemeanor, that firm will send an attorney to represent you. That will be the extent of my preliminary discussion with you. When I call you, I'll let you know what your charge is, your bond amount, if you're entitled to a bond, your special conditions, your next court date for felonies is December 6th, misdemeanors, December 7th. And also I'll appoint an attorney to represent you. And I will ask you if you have any questions, and I can only answer questions related to those 4 things that I just discussed. Each of you raise your right hand for me, please. All right, each of you solemnly swear or affirm any statements or testimony you will give in this first appearance matter not pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, gentlemen, be on standby. We'll do the ladies first.
All right. First. Yeah. Step up, say your name. State your name.
Ice Diallo.
Yes, ma'am. Ms. Diallo, charged with 1 count of aggravated assault with a deadly weapon. It's felony. Your bond is $10,000. There's no contact with Alden Hughley. Can't return to 5758 Highway 85, apartment 113 in Riverdale at this time. If you must return there, ma'am, to get belongings, you must contact the sheriff or the police. They must accompany you within 10 days of your release to get those items that belong to you, ma'am. Your preliminary hearing is the 6th of December, 8:30. And I am appointing an attorney to represent you, Ms. Diallo. You have any questions?
Yes.
Yes, ma'am. Go ahead.
The address 5758 is the apartment under my name. Alden Hughley lives with his mother. Who would I speak to about that?
All right. He doesn't live with you at all?
No, that is a 1-bedroom apartment. He has never lived there ever.
All right, ma'am. I'll remove that condition so you can return freely.
Thank you.
And the only condition will be no contact with Mr. Hughley.
Yes, sir.
All right. You have any other questions?
No, sir.
All right. Thank you. Good luck to you, ma'am.
You too. Thank you.
Thank you.
Go forward, state your name.
Tasha Dyer.
All right. Yes, ma'am. Miss, what's your last name?
Dyer.
Speak up louder.
Dyer.
Oh, okay. This is a fugitive?
Yes, Your Honor.
Okay. Let's do her as last female.
Yes, Your Honor. Next. Step up, say your name.
Yolanda Massey.
Last name is Massey.
Yeah.
All right, Miss Massey. All right, you're charged with 1 count of, or 2 counts of simple assault. It's 2,000 on each of those offenses. 1 count of simple battery, 2,500. There's no contact with Robert Littman. All right, who lives at the 484 Wexwood Drive address?
Me and Robert Littman and his mom.
Yeah.
And my kids.
Okay. All right, it's no contact with him at this time. I'm not putting a stay away from that location, ma'am.
You said you're not?
I am not putting a stay away from that 484 Wexwood Drive location, but it's just no contact with him.
But he stays there as well?
Well, you can decide if you're going to leave or he's going to leave. I'm not going to make you leave on these charges. All right. So you make that decision, ma'am.
Okay.
All right. Your preliminary hearing is scheduled for the 6th of December, 8:30. I'm sorry, the 7th of December at 8:30. And one moment here, looking at your application here. All right, I am appointing an attorney to represent you. You have any questions?
Do I get a reduced bond?
That's as low as it goes, ma'am.
So what's the total?
6,500.
Okay.
All right. All right, thank you.
Sorry for getting out of sequence, Your Honor. Ms. Maitland next.
All right. Thank you. Ms. Maitland. Ma'am, you're charged with, where's she? Did she go somewhere? There we go. Where are you going?
How you doing?
Good morning.
Good morning.
All right, Ms. Maitland, you're charged with 2 misdemeanors. The first one is simple assault, 2,000 is your bond. The next one is simple battery, 2,500, simple battery on a police officer. All right, 4,500 is your total. There is a preliminary hearing for you scheduled for the 7th of December, 8:30. And I am appointing an attorney to represent you. Ms. Maitland, you have any questions?
No, currently, thank you.
All right, thank you.
Moyer.
Crystal Moyer.
All right, Ms. Moyer. One moment here.
All right. I had first appearance on Sunday.
Okay. All right. Yep, exactly. That's what my notes saying. You were first appeared on the 24th.
Yes, sir.
Okay. Do you need anything from me, ma'am?
No, sir.
Okay. All right. Good luck to you. Thank you.
Okay, thank you.
Open court.
All right. Good morning to you, Miss Ografor here. You're charged with 1 count of obstructing an officer. It's a misdemeanor. 1,000 is your bond. December 7th, 8:30 is your preliminary hearing.
Thank you.
And one more thing. All right. I'm appointing an attorney to represent you, ma'am. You have any questions?
No, sir.
Okay, thank you.
Thank you very much.
All right.
What's that name?
Good morning, Your Honor. I'm Pamela Rock.
Yes, ma'am. Good morning to you, Miss Rock. All right. You're charged with 1 count of battery family violence. It's a misdemeanor. 5,000 is your bond. Special condition. You can't have contact with Rakaya Lanier, who lives at the 11962 address.
I do, sir. We're currently making arrangements for her to go back with her father. So.
All right. So let me just make sure here. You all live together, right?
Yes, sir.
Is your house?
Yes, sir.
All right. It's not her house?
No, she's only 16.
Okay. I understand that. I gotta ask. Okay.
Yes, sir.
All right. So it will just be no contact with her at this time, ma'am. I understand the situation. And your preliminary hearing is the 7th of December.
Okay.
At 8:30. And I am appointing an attorney to represent you, ma'am. You have any questions?
Okay. Again, tell me how much is the bond again?
5,000.
Okay. That's all. Thank you so much.
Yes, ma'am. Thank you.
Salazano.
Jordan Salazano.
Yes, ma'am. Ms. Sarazano. You're charged with 1 count of, 2 counts of violation of the Georgia Controlled Substances Act. 1 is possession of MDMA. That's a felony. Your bond is 7,000. The other is possession of less than 1 ounce of marijuana. That's a misdemeanor. It's $1,500. So $8,500 total. Preliminary hearing, 6th of December, 8:30. And I am appointing an attorney to represent you. You have any questions?
No, sir.
All right, thank you.
Your Honor, back to Ms. Dyer, the fugitive.
All right, Robin Humphrey, she was also first appeared already?
Yes, sir. She's not coming today. I believe she was in the infirmary.
Okay.
Yes, sir.
All right, thank you.
Tasha Dyer.
All right, yes, ma'am, Ms. Dyer. One moment. All right, yes, ma'am. So you're here, Ms. Dyer, for the beginning phases of being informed on an extradition hearing or the extradition hearing procedure. All of the rights, the constitutional rights that I outlined to everyone else before you, ma'am, they all apply to you. However, the difference is here, you are before me with a warrant that outlines that you're a fugitive from justice. And the warrant reads that you're wanted by Leon County Sheriff's Office in Tallahassee, Florida, for the offense of damage to property, criminal mischief of $1,000 or more. And they will extradite you, ma'am, to Florida. And so what's happening here is that you are denied bond. I'm not giving you a bond because you're from or wanted from another state. However, you can contest or waive the formal extradition proceeding. What I must inform you is that this hearing is being conducted pursuant to the Official Code of Georgia Annotated, or OCGA Title 17, Chapter 13. What you can contest if you choose to fight extradition are 4 things. 1, whether the extradition documents, that would be the warrant that I just read, and any other documents, whether those extradition documents are in order on their face. Whether, or 2, whether you're charged with a crime that actually exists in Florida. 3, whether you are the person, Tasha Alicia Dyer, whether you are the person named in the request for extradition. And 4th, whether you are in fact a fugitive. If you choose to fight extradition, then you must remain in the Clayton County Jail for up to 90 days. A warrant will be prepared under the seal of Governor Brian Kemp, Georgia's governor, and you will have your formal proceeding. If you choose to waive your formal extradition hearing and return to Tallahassee, Florida, then Tallahassee, Florida Sheriff's Office will have 10 days, I believe it's business days, to come get you. If they don't get you, they can ask for an extension, but generally they get you within that time period or make arrangements to have you transported. So at this time, Ms. Dyer, do you wish to waive your extradition, or you wish to contest or fight the process?
I wish to waive.
All right, yes, ma'am. So there's 7 forms that I completed there, waiver forms. You can go ahead and sign off on those forms. And unless you have any questions, ma'am, that will complete your information on extradition.
You have any questions?
No questions. All right, good luck to you, ma'am.
Thank you, Your Honor.
All right, yes, sir. Deputy Jackson, we'll see you next time.
Yes, sir.
Thank you. All right, Deputy Ricania, it's all you, sir.
Mr. Atkins.
Edward Akins.
Yes, sir. Mr. Atkins, good morning to you. All right, you're charged with the 1 count of misdemeanor public indecency. Your bond is $2,000. Preliminary hearing, 7th of December, 8:30. And I am appointing an attorney to represent you, sir. You have any questions?
No questions. I just paid the bond, and I'll be bringing my own attorney.
Yes, sir. All right. So you're gonna hire your own lawyer?
Yes, sir.
Okay. All right. I'm gonna appoint one. If you choose to hire one, that lawyer will replace the lawyer the hired lawyer will replace the court-appointed one.
Thank you.
All right. You're welcome. Thank you.
Yeah, you can go. Bernard and
Mr. Bernardin, good morning.
Good morning.
You know what you're charged with?
Qualification. So, something like that.
All right, sir. There's no bond today on that offense. All right, bond is denied today. You need to speak with your lawyer about getting a bond. Preliminary hearing is the 6th of December, 8:30. Bond hearing is the 10th of December, 8:30. I am appointing an attorney to represent you, sir. You have any questions?
Not at the moment.
All right, thank you. Good luck to you.
Barry.
Yeah. Yes, sir.
Yes, sir.
How you doing?
Good morning to you. I'm doing pretty good. It's Mr. Barry.
Yes, sir.
All right, Mr. Barry. You charge of 1 count. Criminal trespass is a misdemeanor. 2,500 is your bond.
All right.
Obstructing an officer, misdemeanor, is 1,000.
Did you look at the?
All right, 3,500 is your total.
All right.
You can't go back to the Kroger at 5664 Jonesboro Road. You understand what you're charged with? Special condition of your bond, sir.
Yes, sir.
All right, preliminary hearing, 7th of December, 8:30. I am appointing an attorney to represent you, sir. You have any questions?
Yes, sir.
All right, thank you. Good luck to you, sir.
Thank you.
You up, Dor? Boyd.
Good afternoon.
Yes, sir. Mr. Boyd,
Yes, sir.
how you doing?
I've been better.
I understand that. Well, let's see if I can give you some numbers here so that you can understand where you are going forward.
Sure.
Mr. Boyd, you're charged with 2 misdemeanors, or 3 of them. Possession of a drug-related object is 500 as your bond. Possession of less than an ounce of marijuana is 1,500. And loitering and prowling is 1,000. All right, so far we have 3,000 there. Then you're charged with 2 felonies, both drug offenses, possession of THC and possession with intent to distribute. It's 5,000 on each of those, so that's 10,000 plus the 3. That's 13,000 is your total bond amount, sir. Preliminary hearing is the 6th of December at 8:30. What's your monthly income?
48.
All right, I am appointing an attorney to represent you, sir. You have any questions, Mr. Boyd?
Is there a way to do a speedy trial, or do I have to wait until I talk to my attorney?
Oh, yes, sir. The attorney can file that motion for you. So yes, definitely speak with your lawyer.
Okay.
All right.
All right. Thank you.
All right, yes, sir.
Collins. Go to the computer.
Yes, sir. What's your name? What is it? Nathaniel Collins. I don't see you on my list. Let's see, Nathaniel Collins. All right, one moment. I see you now.
Yeah, he was duplicated on the calendar, Your Honor.
Okay, yeah, Nathaniel Isaac Collins. All right, sir, let's see here. Battery, family violence, misdemeanor. Your bond is $5,000 on that offense. Battery, $5,000. Obstructing or hindering a law enforcement officer is $1,000. Criminal damage to property in the second degree is $1,000. Cruelty to children is $2,000. Your total bond is $14,000. There's no contact with Christy Lewis. You can't return to 537 Woodbridge Drive in Riverdale at this time. If you must return there to get any belongings, you must make contact with sheriff or the police to accompany you and escort you to that residence to get those belongings. And I am appointing an attorney to represent you, sir. You have any questions? Can you hear me?
No,
All right, Deputy Ricania, what's happening here?
You gotta speak up, Mr. Collins. You say
Can you hear me? All right,
Yes,
do you
Your
have
Honor.
any questions?
He says no.
No questions. All right, good luck to you, sir. Thank you.
All right, you can go back. Charles.
How you doing, sir?
Good.
All right, is this Lenny Charles?
Yes, sir.
All right, Mr. Charles, you're charged with 3 misdemeanors here. The first one is driving while license suspended. It's $1,500 is the bond. And 2 other misdemeanors, the bond is $500 each on the display of tag and failure to move over. So you have $2,500 is your total. Preliminary hearing December 7th, 8:30. Are you employed?
No, sir, not at the moment.
All right. I am appointing an attorney to represent you. Mr. Charles, you have any questions?
No, sir.
Okay. All right. Thank you, sir.
Mr. Clayton. Clayton. Hey, come on up. Your turn to go. Your Honor, Mr. Clayton here is present, but during this whole time, he's been kind of popping in and out, leaving. He's leaving right now as we speak.
All right. We'll continue him to tomorrow.
Yes, sir.
Let's continue to October 27th.
Yes, sir.
All right. Thank you.
Ms. Davis.
How you doing, sir?
Good, how are you?
I'm good here. Mr. Davis. Theft by receiving stolen properties, which you're charged with, it's felony. $3,000 is your bond. It's your grandmother?
Pardon?
Your grandmother?
Yeah.
All right. Is it Mosey?
Mosley.
Mosley?
Yeah.
All right. No contact at this time with Kathy Mosley. Okay. And that would be a bond. It could be higher, but it's lower than it should be, sir. As a word of pointer here, sir. Please be certain to amend that relationship after this if you can. And I am appointing an attorney to represent you. You have any questions, sir?
No.
All right. Thank you.
Appreciate it.
James.
How you doing, sir?
All right.
All right, one count of disorderly conduct, misdemeanor, 1,500. December 7th, 8:30 is your preliminary hearing. All right, Mr. Deans, I'm appointing an attorney to represent you, sir. You have any questions?
No, sir.
All right, thank you.
Paul.
Yeah.
Yes, sir, Mr. Hall. All right, you're charged with 5 counts here. 2 of them are misdemeanors. The misdemeanors are possession of a drug-related object, 500 is your bond. Loitering or prowling is 1,000. Then you're charged with 2 counts of violation of the Georgia Controlled Substances Act. All right, it's possession of over an ounce of marijuana and possession with intent to distribute. It's 8,000 on each of those 2. And then you're charged with possession of THC. That's a violation of the Georgia Controlled Substances Act. That's 5,000. Preliminary hearing, December 6th, 8:30. And I am appointing an attorney to represent you. Mr. Hall, you have any questions?
No.
All right, thank you, sir.
Mr. Lawson.
Who's this?
Richard Lawson.
Lawson, okay. How you doing, sir?
Good.
All right, charged with misdemeanor loitering or prowling, misdemeanor possession of a drug-related object. The loitering or prowling, the bond is 1,000. The drug-related object possession of that is 500. And then you're charged with 3 felony counts of possession of or violation of the Georgia Controlled Substances Act. You have possession of Schedule 2 methamphetamine, possession with intent to distribute, and possession of Schedule 2 cocaine. On each of those 3, it's 8,000 each is your bond. And then lastly, you're charged with possession of a firearm or knife during the commission of a crime. That is 5,000 is the bond. Preliminary hearing is the 6th of December at 8:30. And I am appointing an attorney to represent you, sir. You have any questions?
No.
All right, thank you.
Thank you.
Yes, sir. What's your name?
Dominique Mack.
All right, Mr. Mackins. So you're charged with theft by taking, misdemeanor. 2,000 is your bond. Simple, well, not simple, but battery, family violence. And that is second or subsequent offense. It's a felony. 10,000 is your bond on that offense. Aggravated assault is 15,000. Criminal damage to property, 2,000.
So what's the total?
29,000 is your total. There's no contact with Chanel Buckner. You can't return to 7147 Richardson Parkway in Morrow. If you must go there, you must make contact with the Clayton County Sheriff or police or local Morrow police.
Wait, don't interrupt. I'm sorry.
Well, you understand the special conditions, sir?
The who?
Special conditions.
Yes, but what's the address and where is that to?
Okay. The address is 7147 Richardson Parkway in Morrow. All right. That's the address where this incident happened. So at this time, you can't return to that location.
Okay.
All right. Sir, I'm appointing an attorney to represent you, Mr. Mackins. You have any questions?
Is there a way that I don't know when my attorney can contact me, and will I be able to get a speedy trial?
Yes, sir. That's all great questions for your lawyer. And once your lawyer makes contact with you, certainly you can get those questions answered.
Okay. 29,000, you said?
Yes, sir.
Okay. Mr. Matthews? What's going on, y'all?
How you doing, Mr. Matthews?
Good.
Got a lot of charges here, sir. You know everything you're charged with?
No, sir. I just know a couple of them.
All right. So it's aggravated assault with a deadly weapon, murder, armed robbery, possession of a weapon, during the commission of a crime, 2 counts of possession of a weapon or handgun, and armed robbery and possession, another count of possession of firearm during the commission of a crime. Sir, unfortunately, I can't give you a bond on any of those offenses today. So it's no bond on any of them based on the nature of the charges, sir. Your preliminary hearing is the 6th of December. And let's see, the bond hearing is December 10th. And I am appointing an attorney to represent you, Mr. Matthews. Yes, sir.
Yes, I'm hiring one.
All right, I'm going to appoint one now. Serious charges, right? So when you get your lawyer on board, that lawyer will then substitute the lawyer that I'm appointing to you, okay?
Yes, sir.
All right, you have any questions?
No, sir.
All right, thank you, sir. Good luck to you, Mr. Matthews.
Your Honor, did you have a Robinson Victor on schedule for today, the calendar?
Last name is Vic. Yeah, I have him. I think he was an add-on.
Yes, sir. He's present.
Okay.
He's coming up now.
Okay. All right.
And just for the record, Stephens Price, he refused to come to court today.
Refuse. All right.
Yes, sir.
All right. Mr. Victor Robinson?
Yes, sir.
Yes, sir. You charge a 1 count of disorderly conduct, some misdemeanors. $500 is your bond, sir. Preliminary hearing is 7th of December at 8:30. All right, sir. I'm appointing an attorney to represent you. You have any questions?
No, sir. You said my bond 500?
500, sir.
Okay, thank you, sir.
All right, you're welcome.
Summers. Come on. What's that? On the camera.
All right, it's Mr. Summers.
Yes, sir.
All right, Mr. Summers, sir, you're charged with 1 count of possession of a drug-related object is 500 is the bond. 1 count of loitering or prowling is 1,000. And you have a preliminary hearing of the 7th of December at 8:30. I appoint an attorney to represent you, sir. You have any questions?
No, sir.
All right, thank you.
Thank you.
Thank you.
Tucker.
All right, Mr. Tucker, how you doing today?
Great, you?
I'm doing pretty great myself here. Criminal trespass is the offense. Misdemeanor. 2,000 is your bond. You live with your mom?
No, that's my grandma.
It's your grandma? All right, so it's 2,000 is the bond. Preliminary hearing is the 7th of December, 8:30. Mr. Tucker, I am appointing an attorney to represent you, sir. You have any questions?
No, sir. Thank you.
All right, thank you.
Mr. Alden Walker.
Good morning, Judge.
All right, good morning. One moment here. All right, yes, sir. What's your name?
I didn't walk. If you don't mind, can I tell you a couple things before we start?
Let me tell you first, and then you might have some other questions.
All right.
All right, so it's aggravated assault with a deadly weapon. It's 10,000. Pointing a pistol at another is 5,000. Theft by taking is 2,000. Criminal trespass damage to property is 2,000. Terry Allwood, no contact directly, indirectly, third party, social media. Don't return to the 893 Martha Drive, Forest Park address.
Yes, sir. How much is that bond out again?
19,000 is the total. All right. If you must return to that 893 Martha Drive, Forest Park address, you must have the Clayton County Sheriff or police or local Forest Park police go with you.
Yeah.
All right. Preliminary hearing. 6th of December, 8:30.
Okay.
And I am appointing an attorney to represent you. All
Okay.
right, sir. What do you want to tell me and what any questions you have?
Well, I guess it don't even matter. But I was just gonna tell you, I'm enrolled in school, trying to get to school, trying to do the right thing, get up out of it.
Yeah, it does matter, sir. And that's exactly what you need to be continuing doing, sir. So keep doing it.
Yeah.
Put this behind you, move forward, and let this just be a stumbling block in life, and you'll be good to go. We all make mistakes, so you can get over this like everybody else, sir.
And you said 19,000, right?
Yes, sir.
I appreciate you, Judge.
All right, no problem. Thank you. Good luck to you.
No problem.
All right.
Christopher Walker.
How you doing, John?
How you doing, sir? Who are you?
Christopher Walker.
All right, Christopher Walker. Mr. Walker, you have to come back tomorrow, sir. All right. I don't have your paperwork with me. You're charged with, I believe it's a criminal trespass, but I don't have your warrants. So you have to come on back tomorrow.
Okay. Like what warrant though? If you don't mind me asking.
The warrant number 2021WA18511.
What you mean? If you don't mind me asking, because I'm not sure. I mean, I'm not.
What I'm saying is I can't give you a full bond because I don't know what the warrant says because I don't have it. All right, so
okay,
you can come back tomorrow.
All right,
and we'll have it then.
Mr. West.
Good afternoon, Your Honor.
Yes, sir, Mr. West. Good afternoon. Sir, you're charged with one count of driving under influence of alcohol less safe. It's 5,000 is that bond, and following too close is 500. So 5,500 is 2 misdemeanors. Preliminary hearing is December 6th, 8:30.
So I can bond out today?
Yes, sir. And I will appoint an attorney to represent you.
Okay.
All right. You have any questions?
No, sir.
All right. Thank you.
Mr. Wilkinson. What? I got it. He's coming up, Your Honor.
Yes, sir. Yes, sir. Who are you?
Gerald.
You gotta speak up loud.
Gerald.
That's Mr. Wilkinson.
Oh, this Wilkerson. Okay. All right, Mr. Wilkerson. You're charged with one count of violation of the Georgia Controlled Substances Act, possession of cocaine. $8,000 is your bond. Possession of less than an ounce of marijuana is $1,500. Possession of a drug-related object, $500. Loitering or prowling is $1,000. Obstructing an officer, $1,000. Preliminary hearing scheduled for December 6th at 8:30. And I am appointing an attorney to represent you, sir. You have any questions?
No.
All right. Thank you, sir.
Arnell Williams.
One moment, Mr. Williams. Said Arnell Xavier Williams.
Yes, sir.
Is this the same person as Xavier Leon Williams, or it's two different people?
Your Honor.
Okay, all right. I just wanted to make sure. All right, Mr. Arnell Xavier Williams. Sorry about that. I had to make sure. Okay. All right. Sir, you're charged with 1 count of criminal trespass. It's a misdemeanor. $2,500 is your bond. You can't go back to the Kroger at 5664 Jonesboro Road in Morrow. All right. And I am appointing an attorney to represent you, sir. You have any questions?
I have a question about the bonding thing. Can I do
About the what?
the bonding? Is it okay I do the 10% back or pay the full?
Say that apart again. I heard you say you have a question about the bonding, and then I couldn't hear you.
Yeah, my options with the bond. Like, how can I pay it?
Oh, you have to talk with the bonding company. They'll give you all your options.
All right, good. Thank you.
Yes, sir.
Well done.
Xavier Williams.
All right, Mr. Xavier Williams, how you doing this morning, sir?
Well, Your Honor.
All right, so you have 2 misdemeanors. One is loitering or prowling, it's 1,000. The other is open container is 5,000. I'm sorry, 500. All right, those are the 2 misdemeanors. The other counts are felonies, and there are 4 of them. Possession of marijuana with intent to distribute. Possession of hydrocodone with intent to distribute. Possession of marijuana more than an ounce, and possession of hydrocodone. It's 8,000 on each of those 4 offenses. Your preliminary hearing is scheduled for the 6th of December, and that's at 8:30. And I will appoint an attorney to represent you, sir.
Thank you, Your Honor. And I just wanted to know my total, Your Honor.
All right, let's do it. 8,000 times 4.
32.
And then, let's see, 33 plus 5. So 33,500.
Okay.
33,500.
Okay, thank you, Your Honor. And can I ask for a bond reduction? Can I get a bond reduction? Because I need to get back to my family and work and everything that I left for this situation.
I understand, sir, but you got to understand the nature of the offenses. You have to talk to your lawyer and see what the district attorney says and see if they can consent to a bond reduction.
Yes, sir.
All right.
Thank you.
All right, good luck to you, sir. It'll work out.
Vice versa. Thank you.
Yes, sir. All right. So Stevens refused. Prince Christian Stevens refused to come out is what I got. And also we got
Humphrey.
Was it Humphrey was in the infirmary?
And Jamal Clayton, he was the one who was being non-compliant, refusing to stay seated, just kept going in and out this whole entire time.
Okay. All right. Yeah, I just wanted to make sure. So so that takes care of everyone else then.
Yes, Your Honor.
All right, Deputy Ricani, appreciate it. We'll see you next time.
Okay, the court will now call the case of State of Georgia versus Keith Stocks. Case numbers 2021 CW 54300 and 2021 CW 54301. Present for the hearing, here representing the state is Ms. Audrey Lewis. The defendant, Mr. Keith Stocks. Are you Mr. Stocks?
I'm the trustee on behalf of Mr. Stocks.
Is currently present and incarcerated in Clayton County Jail. His attorney, Mr. Stephen Little, is present. You all may proceed.
Thank you, Your Honor. Officer Justice, can you raise your right hand? You swear and affirm that the testimony that you shall provide to the court today shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do swear.
Okay. And can you give us your,
I'm sorry.
I think that was Mr. Stocks.
Okay, Mr. Stocks, you cannot speak out during the hearing. Thank you.
Your Honor. Officer Justice, can you please state your complete name?
I'm Sergeant Justice, Jonesboro Police Department. Sergeant Stephen Justice with Jonesboro Police Department.
And were you working with Jonesboro Police Department on September 3rd of this year?
I was.
Okay. And did you have the opportunity to come into contact with the defendant, Mr. Stocks?
I did.
Okay. Was he alone when you made contact with him?
He was alone with at the Jonesboro City Hall. If you're meaning alone was he accompanied by any other persons? No, he wasn't, although he was with my lieutenant and chief of police.
Okay. At some point, was there also a DeMarcus Alexander that was interviewed as a part of this investigation?
Not that I'm aware of.
Okay.
I'm not just for the record, I'm not the original.
Gotcha. It's Officer Fawn who.
Yes, ma'am.
Officer. Okay. So when you made contact with the defendant, he was alone. Do you see him on this Zoom call?
I do.
And can you identify him by what he's wearing?
Yes, ma'am. He is wearing a red jumpsuit with a white mask, black male, short black hair.
Okay. And you advised that you made contact with him around the Jonesboro area?
It was at the Jonesboro City Hall.
Okay. Is that in Clayton County, Georgia?
That is correct.
Okay. And how did you come to be involved in this case?
I was called by my lieutenant, Lieutenant Newsom, to the Jonesboro City Hall in reference to a subject that has possibly had a warrant for his arrest out of Jonesboro.
Okay. And are you familiar with any other part of the investigation other than ascertaining his status as wanted?
I was briefly advised about two subjects that were involved in being inside of inside of a business.
Okay. Do you know the name of the business?
Right offhand, no, ma'am, I do not.
Would it refresh your recollection to look at a report?
I'd have to look at Sergeant Fawn's report.
Okay, and were you the approving officer of that report?
I would have to check that report also to verify that.
Okay. Just take a moment to do that and let me know.
Okay. Just give me one sec.
No problem. Just let us know.
Sorry, my system's running a little slow, so it's taking just a minute. Could you, do you happen to have the original report case number? From what I see, it's not the right one, from what I can tell.
Your Honor, I want to object to this line of questioning.
I didn't ask a question.
What's that? I'm sorry.
Your Honor, I've kind of an objection to this procedure that's going on here. I mean, obviously, Officer Justice is not testifying to any sort of personal knowledge he has. Is the state's intention to just have him read another officer's report into the record?
He asked for an opportunity to refresh his recollection, and he needs that report number to refer to. That's where we are procedurally.
He also testified that he wasn't involved in this investigation. So is he refreshing his recollection, or is he learning these facts from reading this report?
He is the approving officer of the report, and the statute allows in a preliminary hearing for hearsay.
So he was there. Officer Justice was there.
He's testified that he was involved in ascertaining, making contact with him in reference to whether or not he was wanted at this particular time. He's listed as the approving officer in this police report. I think that my investigative assistant assumed that he was the reporting officer. So he was the one that was requested to be here today to report. In this case, he is the approving officer. And so I do think at this point, procedurally, he is allowed to look at the report to see if that refreshes his recollection. If it doesn't, then that ends the line of questioning. But
when it comes to the actual original report,
hold on 1 minute, Officer Justice.
I'm sorry.
Sergeant Justice, thank you.
My concern here is that this may not be refreshing his recollection.
Yeah, and I
can't have a recollection if he never investigated it.
Let me just say this. Do you think it's more appropriate to have the officer that actually was involved in this particular incident of the criminal trespass and obstruction of an officer?
I mean, we can request to reset it, but I will say that he is allowed to use their collective knowledge. If he was there on the scene and approved the report and was involved, then he can testify to it.
Okay, I guess my question is, at what point, Officer Justice, did you arrive on the scene?
I arrived to take Mr. Stokes into custody a few days after this original report. And Sergeant Fawn is the officer who got the warrants signed by the court for Mr. Stokes' arrest. I arrested Mr. Stokes based upon the warrants. Okay. I had no indication or knowledge of what went on prior to me meeting with Mr. Stokes at the city hall.
That's what I need to know. So,
and then we need to
reset this, and we can reset it 1 week, but we need to reset this because we need the proper officer here on this case.
And Your Honor, I would object to the reset. I mean, the state did have an opportunity to subpoena their witnesses and investigate to determine if they had the proper witnesses to prove probable cause.
Is the officer, have you all checked to see if the officer is available now?
We can certainly see if he is available, but I mean, to the extent that he's not, we would request a 1 week recess to have the proper officer present.
Okay. Let me see how. Okay, while you all do that, I want to go ahead and handle the last one on the calendar. I only have one more listed on my calendar, and that's McConnell. I think that was the individual that wants to represent himself.
Did we also have Gary Sargent? Because that actually is, it's a Sergeant Fawn and Sergeant Justice as well, but it's the reverse. This time, Sergeant Justice was the reporting officer and Sergeant Fawn was the approving officer on Sergeant.
Okay. I didn't have Sergeant written down. Okay. All right. Well, you all can, for now, you can take Stocks back. We may need him again, but you can take them back for now. And if you would bring Sergeant.
She said McConnell.
Yes, McConnell.
Sergeant.
McConnell.
They were gonna restart, but
They want Sergeant
That's what I thought they were gonna. Just go back. Probably the same, sir. No, the thing is checking and see if the time officer. Okay.
Right, sir?
Yes, sir.
Hello, man. Your Honor. Stop it. Come here.
Yes.
Yes, ma'am. Do you want to stop to go back to his house? Or you want to see him again?
Oh, just hold him just for a second. We're trying to see if we can get the officer on his case. So just hold him. Is this Sergeant?
No, she means Sergeant.
No, ma'am. He's here.
We're asking for Sergeant. Connell will be after Sergeant.
Okay, ma'am. Sergeant coming. You go, man.
And who's going to handle Sergeant? You, Mr. Little? Okay. All right. I'm sorry, Mr. Steele.
Yes, Jana.
It's been a long day.
No, you are fine. It is.
Court will now call the case of the state of Georgia versus Gary Sargent, case number 2021 WA 16205. Present for the hearing via Zoom here representing the state is Mr. Jonathan Steele, the defendant, Gary Sargent. Are you Mr. Sargent?
Yes, ma'am.
He's present and currently incarcerated in the Clayton County Jail. His attorney, Mr. David Suh, is also present. You all may proceed.
Thank you, Your Honor. Sergeant Justice, may you please raise your right hand? Do you swear to tell the whole truth and nothing but the truth, so help you God?
I do swear.
Can you please state your full name for the record?
I'm Sergeant Stephen Justice, Jonesboro Police Department.
And how long have you been employed there?
A little over a year.
And were you employed there on September the 11th, 2021?
I was.
And on that particular day, were you called out to 8240 Tara Boulevard, Jonesboro, Georgia?
Yes, sir, I was.
And is that location in Clayton County, Georgia?
Yes, sir, it is.
And can you please tell us why you were called out to that location?
I was called out to the location in reference to a dispute between a male and female.
And did you speak with anyone while on the scene?
I did. I spoke with Miss Hurd, Tiffany Hurd, and her sister. I cannot recall her first name, and Mr. Sargent.
And what did Tiffany Hurd say happened?
I'm sorry, let me refresh my memory with with the report that I wrote.
Okay, thank you.
Ms. Hurd advised me that her and Mr. Sargent were involved in a verbal argument, and that at some point, Mr. Sargent supposedly threw a frozen meal at her, which missed her. Apparently, she threw it back at him when he supposedly pushed her at some point during the altercation, during the argument.
So physical contact occurred?
Yes.
And can you please describe it?
Again, Ms. Hurd advised that Mr. Sargent pushed her and possibly grabbed her around her neck area in a choking manner.
And at any point, did Mr. Sargent pull Ms. Hurd's hair?
She advised that he did. He advised that he didn't. But there was no physical evidence showing one way or the other that either he did or didn't.
And can you just tell us who you came to conclude made contact first?
My conclusions were is that Mr. Sargent pushed Miss Hurd first. That's just my conclusion of my report.
And did you observe any injuries to Miss Hurd?
No.
Did any of her clothing seem disheveled, her hair?
No. Well, her hair did. I'm sorry. I apologize about that, but her hair was a little messy, but I don't know if that was due to the altercation or if that was due to just her physical general appearance.
And is the person Ms. Hurd described that made the contact on the Zoom call?
Mr. Sargent is on the Zoom call.
And can you describe what he's wearing right now?
Sure. He is wearing a orange, or appears to be an orange jumpsuit, and a blue face mask.
Your Honor, please let the record reflect that the defendant has been identified.
The record is reflected.
And what is the relationship between the defendant and Miss Tiffany Hurd?
I believe Miss Tiffany Hurd is Mr. Sargent's girlfriend's sister, or Miss Tiffany Hurd is either. I'm sorry. Maybe Miss Tiffany Hurd is the girlfriend or baby's mama of Mr. Sargent.
Did you need to check your report to?
Yes, please.
Okay.
Okay, I believe Miss Joyce Hurd is the sister of Miss Tiffany Hurd, which is Miss Tiffany Hurd is the girlfriend or baby's mama of Mr. Sargent.
Okay, so I want to break this down and clarify.
It's a kind of confusing.
Yeah, so Miss Tiffany Hurd is Joyce's Hurd's sister.
Yes.
And Joyce Hurd is Mr. Sargent's girlfriend.
I believe it is. That is correct.
Okay. I just wanted to clarify that. Thank you. And at any point, did you make contact with the defendant?
I did.
And did the defendant state to you that he had gotten into an argument with Ms. Hurd?
He did.
Did he, can you just please tell us what exactly he said to you regarding the argument?
Sure. He advised me that him and Miss Hurd had gotten into an argument. They didn't specify what the argument was over. It's just an argument between boyfriend, girlfriend type thing. And at some point, that Miss Hurd threw a box of frozen food at him, which in turn he picked up the frozen food and threw it back at her. Both of them advised that they missed, and at some point, Mr. Sergeant, at some point pushed her out the room and then locked the door or something to that effect.
So I want to clarify. So there was initially Ms. Hurd saying Mr. Sergeant pushed her.
Yes.
And then on a separate kind of connected incident, he pushed her out of a room.
Yes.
Okay.
Or they had left the room and he locked the door behind them. Something to that effect. They all Miss Hurd and Mr. Sergeant were slightly intoxicated at the time of this incident. So getting a clear understanding about what took place was very difficult.
And so how did you come to conclude that Mr. Sergeant was the aggressor?
For the simple fact that he admitted that they were both involved in an argument. Things were thrown inside the room, and that the testimony of both Miss Hurd's and her sister, advising that Mr. Sergeant had was involved in a pushing contest and possibly even a choking issue while inside the room.
So you mentioned earlier Joyce Hurd being Mr. Sergeant's girlfriend.
Sure. Yes.
Did you make contact with Joyce Hurd?
I did.
And did she state anything about the argument that took place?
She just stated that they were having an argument, which at some point Mr. Sergeant pushed her and put his hands around her neck and said that he choked her.
And at any point, did Ms. Tiffany Hurd or the defendant state that they had formerly lived together or currently live together?
Tiffany, they did not advise that they lived together. She was just visiting at that point, nor do I have any indication that they actually lived together at any point.
And I'm sorry to go backwards, but this location that you arrived to, was it a hotel?
It is an extended stay hotel, yes, sir.
And did the defendant state to you of anything of interest other than what we've discussed?
He advised that he did not choke her. I mean, of course, he did tell me that he did lock the door after they left. But other than that, I do not recall anything of interest.
Thank you, Sergeant Justice. No further questions, Your Honor.
Thank you. Mr. Seth?
Thank you, Your Honor. Hello, officer.
Good morning.
Good morning. Let's just confirm a few things. Are you post-certified?
I am.
And how many years have you been post-certified?
Since 2006. So a little over 10 years, I guess. 15, 20 years. 15 years. All runs together.
Now, do you typically wear a body-worn camera?
I do.
And was your body-worn camera on for the time during this investigation?
I do believe it was, yes, sir.
Now, you mentioned that it seemed everybody was intoxicated at this time.
Yes, sir.
Could you tell me about the mood of everybody? Like, as in, was everybody amped up? Was everybody relaxed? Tell me about the mood of everybody.
Miss Joyce Hurd was kind of, I don't want to say amped up, but she was upset. Miss Tiffany Hurd, of course, was upset. And Mr. Sergeant appeared to be somewhat calm and then got upset when I advised him that I was going to place him under arrest for the simple battery charge.
Now, you also mentioned that it was because of their intoxication. It was it was hard to determine exactly what happened. Is that based on just the nature of people, what they were saying, or more of the environment, or both?
Both really, because like I indicated earlier, is that each individual appeared to be in an intoxicated state. So it's hard to decipher through the slurred speeches and then trying to figure out who was the aggressor in the incident.
I think I just have one more question. I just want to confirm, you didn't see any damages or any marks on anybody's neck. Is that what you wrote on the police report?
No, that is what I wrote, and I did not observe any recent indications of Mr. Sergeant grabbing Miss Heard around the neck. No red, no bruising, nothing to that effect.
And approximately how much time had passed between when the 911 call was made and when you arrived for the investigation?
If I had to take a guess, it'd probably be 5 to 10 minutes, if that.
Thank you, officer. No further questions, Your Honor.
Thank you. Anything else, Mr. Steele?
No, Your Honor.
Any witnesses for the defense? Any witnesses for the defense?
Oh, apologize, Your Honor. No, Your Honor.
Argument?
I'll reserve for rebuttal, Your Honor.
Your Honor, we will submit that because there's a lack of a thorough investigation, that probable cause is not sufficient, and that the charges be dismissed.
Thank you. Based on the evidence submitted before the court today, I do find that sufficient evidence to bind the case over to state court. Thank you.
Thank you, Your Honor.
You're welcome. And let me just inquire as to the officer in stocks. Were you all able to get anybody?
I was just about to call him if you need me to call him.
I think they were calling him at the office. I mean,
I believe he works tonight, so he may not be at the office. However, I could try to contact him and see if I can wake
Mr.
him up.
Steele, is that something your office is?
Let me try to ping Ms. Lewis.
No, I'm here. I was informed that I think Sergeant Justice was reaching out. I don't think we've been able to reach him at this time.
Okay.
We would ask to continue it.
Okay. No problem.
Okay.
But until then, Judge, am I good to?
Yeah, I just was making sure they didn't need you anymore. So yes, you're free to go.
Yes, ma'am. I'll give Officer or Sergeant Fawn a call.
Thank you.
Yes, ma'am.
Okay, so while we're waiting on that, I'm going to hear McConnell. And Mr. Little, I'm going to ask you just to kind of stand by. I know he wants to represent himself, but if at any point during the hearing he decides that he needs a little help, then I may ask you to represent him, okay?
Sure, Your Honor.
Thank you.
Hello.
Hello.
Yes.
All right, Mr. McConnell, the court will now call the case of the state of Georgia versus Huntley McConnell, case number 2021 WA 15790. Present for the hearing here via Zoom, representing the state is Ms. Audrey Lewis. The defendant, are you Mr. Huntley McConnell?
Yes, I am.
Okay, Mr. McConnell is present and currently incarcerated in the Clayton County Jail. For the record, Mr. McConnell has elected to represent himself, even after being given the opportunity to speak with an attorney. I have Mr. Little, Mr. McConnell, I have Stephen Little, who's an attorney here.
Okay.
Just in case you decide at any point during the hearing that you would like to be represented. Okay.
All right, won't be necessary.
Okay. Well, just in case.
All right, thank you.
You're welcome. Okay, Ms. Lewis, you may proceed. And just know that Mr. McConnell, you will only be allowed to speak when asked of. So please do not speak out during the hearing. Okay, Ms. Lewis.
Thank you, Your Honor. Officer Hunt, good afternoon. Can you state, I'm sorry, before I get you to do that, can you raise your hand? Do you swear and affirm that the testimony that you shall provide to the court today shall be the truth, the whole truth, and nothing but the truth, so help you God? And you're on mute, so you didn't quite catch that.
Not Jim.
Good. Can you hear me now?
Yes. So I'm going to ask. Okay.
I do.
Okay. Can you tell us your name and where you're employed?
Officer Hunt, employed with the City of Atlanta Airport Division.
Okay. Were you working in that capacity on September 4th of this year?
I was.
And pursuant to your duties as a police officer at the airport, did you come into contact with the defendant, Mr. McConnell?
I did.
Okay. And do you see that individual here on the Zoom call?
Yes, ma'am.
Can you identify him by what he's wearing?
White Caucasian male wearing an orange jumpsuit with a blue mask on.
Okay. Thank you. And Your Honor, may the record reflect that the witness has identified the defendant?
The record is reflected.
Okay. You advised that you made contact with him. Was this at the airport?
Yes, ma'am.
And is that airport located inside of Clayton County, Georgia?
It is, ma'am.
Okay. Why did you make contact with him?
I responded to a call on a Concourse C-42 in reference of a male that was walking around with his pants down to his ankles and attempting to kiss and hug on passengers that he did not know.
Okay. And in making contact with him, were you able to ascertain if he was a passenger on this flight, or I guess why was he there?
He did have a valid ticket at the time. I spoke with Delta representative. His name is in the report, but he's the red coat that was on shift at the moment. He advised he did have a plane ticket, but he was actually denied boarding privileges after the incident took place of him proceeding to do the acts that he was accused of doing.
And this is what you testified to earlier, that trying to kiss people that did not know him and did not want him to.
While his pants were around his ankles.
Okay. You advised that his pants were around his ankles. Was there any genitalia exposed?
No genitalia exposed. I mean, if you like, body cam footage caught quite a few of the complainants that advised the same narrative, that he was being very touchy-feely, attempting to kiss people while his pants were around his knees, around his ankles, some sort.
Okay. Now I know you said attempt. Was he actually successful in making physical contact with any of these people?
Physical contact was made, but the kiss wasn't followed through with. The one passenger I spoke with, I didn't get her name because she did not want to press any charges, and she's from out of state. But my body camera footage, pretty much you can listen to her whole testimony on the camera footage, and she basically says that she felt very, very violated, with him attempting to do so. But at the same time, she didn't want to press any charges at the time because she's wanting to catch her flight and leave.
Okay, so you testified that he was then denied the opportunity to board. Was he ever advised to leave the area?
He was. He was advised to leave the area by the Delta Redcoat. He was advised his boarding privileges with Delta was no longer any good. And at that point, he could not be in the secured area, which he was in, not having a boarding pass.
Okay. And once those individuals advised him that he could no longer be there and that he needed to leave, did he in fact leave?
No, he did not. After advising him, he was no longer allowed to be in the area. I advised him, and my job at that point was to escort him off of the secured area. And I was going to give him a ride back to the front of the airport so he could try to rebook another ticket if possible. That's what he.
I think you froze. Officer Hunt, you froze after you said you were going to take him back to try to see if he could book another ticket.
Yes, ma'am. I was going to take him back to try to rebook, but at the time, I advised him that I needed to escort him out of the secured area. He refused to do so, stating that he's going to go and catch another flight and go where he wanted to go and proceed to walk past me. At that time, I attempted to stop him, to escort him back to the back outside to where my patrol car was at so I can escort him. While doing so, he pulled away from me. And at that point, I simply escorted him to the ground and handcuffed him.
You said that when he proceeded to walk past you after you tried to, I guess, engage him. Where was he headed? What direction was he headed in?
Not towards the gate where I parked my vehicle, so I could escort him out. He was going the opposite direction.
And if he would have continued in the opposite direction, what does that lead to?
It would have led back towards more gates, towards the center area of Concourse C, which is a big concourse.
Okay, so would this have still been the restricted area that he was told he couldn't have been in? Okay, so he was headed to continue in the area where he had told he was not allowed to go.
Yes.
Okay. And because he did not leave, you placed him under arrest?
Yes. At that point, he was in violation of criminal trespass for not leaving the area. Once being told he was could no longer be there and given the opportunity to leave on his own power, he refused. At that point, he was arrested for criminal trespass.
Okay, thank you. Your Honor, I don't have any further questions of this witness.
Okay, Mr. McConnell, do you have any questions for Officer Hunt?
Yes, I do. Okay. Officer Hunt, you testified that I was advised by the local personnel. Is this true? That I was not allowed in the concourse?
Yes.
Did you witness this?
Yes.
You sure?
Yes.
Okay. Did you give me two options? One, to go onto another gate, or to be escorted off the property?
No.
You sure about that?
I gave you two options, telling you if you refuse to leave, that if you did not walk out under your own power, I would have to take you out. Those were your two options.
Can you quote that again, please?
If you refuse to leave the area under your own power and not walk out, I would have to escort you out.
Could you repeat what you said earlier about take me out?
Your Honor, I'm going to say asked and answered.
Yeah, sir, he said it already. He doesn't have to say it twice.
I just want to get accurate testimony, Judge.
You just want to get what?
I just want to get accurate testimony for the record, Judge.
Yeah, well, just make sure you listen up, because if he doesn't have to say it twice.
All right, okay. Let's see here. That's all I have for Officer Hunt.
Okay, thank you, Mr. McConnell. All right, anything else, Ms. Lewis?
No, Your Honor.
Okay. All right, Mr. McConnell. I never advise defendants to testify, as you know that you can't incriminate yourself.
I'm glad to testify.
You would like to testify?
Yes, I would like to testify.
Okay, all right.
Okay. I'm sitting at the airport. I was advised to the Russian rules.
Your Honor, and I apologize. I don't want to interrupt.
One thing, I did not interrupt her.
McConnell, but I don't believe he's sworn in.
Oh, thank you. Raise your right hand, Mr. McConnell. You swear affirm the information given before me is the truth, the whole truth, and nothing but the truth to help you?
I do swear.
Thank you.
Okay, so under Russian rules, it says that girls who refuse their masters are under
what rules?
Under Russian rules.
We're not under Russian rules.
I understand that on the airport, they do follow those rules, miss.
Go ahead, sir.
Okay, so basically I'm there to save those girls' lives, okay? And basically when they refuse, they get punished very horrible. That's all I have to say.
Thank you. Argument? I'm sorry, did you have any witness? I'm sorry, do you have any questions, Ms. Lewis?
No, Your Honor, no questions on behalf of the state.
Okay, argument.
Your Honor, we would just rest on the evidence provided through the testimony of Officer Hunt.
Okay, all right. All right.
I'd like to go ahead. Go ahead. I'm sorry.
Okay, Ms. McConnell.
Okay, under Edict 45 of the Russian rules, I declare myself not guilty.
Thank you, Mr. McConnell. Based on the evidence presented before the court today, I do find sufficient evidence to bind the case over to state court. Thank you. You may be excused, Mr. McConnell. You can take Mr. McConnell back.
Go back to.
The court will now call the case of the state of Georgia versus Willie Octavius Gordon, case number 2021 WA15625. Present for the hearing, here representing the state via Zoom, is Miss Audrey Lewis. The defendant, Mr. Willie Gordon, is present. Are you Mr. Willie Gordon?
Yes, ma'am.
Currently incarcerated in the Clayton County Jail. His attorney, Mr. Stephen Little, is also present. You all may proceed.
Thank you, Your Honor. State's going to call Officer Mercedes Ward. Officer Ward, please raise your right hand. You swear in the following the testimony that you shall provide today shall be the truth, the whole truth. So help you God.
Yes, ma'am.
State your name for the record.
Mercedes Ward.
Okay, and where are you currently employed, Officer Ward?
Clayton County Police Department.
Okay. And how long have you been there?
I've been there 5 years.
Okay. In the course of your carrying out your duties as a Clayton County Police Department officer, did you have the occasion to come in contact with the defendant, Mr. Gordon?
Yes, ma'am.
Where did you come into contact with him?
I came into contact with him near the entrance ramp to 75 southbound from Old Dixie.
Okay. And what county is that in?
It's in Clayton County.
Okay. Now, you indicated that you made contact with Mr. Gordon. What time of day was this and what was the date per your recollection?
Per my recollection, it was September 1st, and then it was about 4 o'clock in the morning.
Okay. You said that you made contact with him near the 75 ramp near Old Dixie. What was your purpose of making contact with him?
I conducted a traffic stop on a vehicle who had its high beams illuminated.
Okay. And when you made contact with that vehicle, who was driving it?
I would have to refresh my recollection from my report, if that's okay.
Okay. Just please take a look at that and then look up when your recollection has been so refreshed.
All right. So the driver of that vehicle was Clarence Cross III.
Okay.
And the defendant, I believe, was the front passenger.
Okay. So you identified Mr. Gordon as the front passenger. Do you see him on this Zoom call?
Yes, ma'am.
And can you identify him by what he's wearing?
He's wearing a white jumpsuit and a white mask.
In Your Honor, may the record reflect that the witness has identified the defendant?
The record is reflected.
Okay. Now you advised that there was the driver, Mr. Gordon, Was there anyone else in the vehicle?
There were 3 additional occupants in the rear.
Okay. Now, once you made contact with this vehicle and its driver, did your investigation go beyond a traffic stop?
Yes, ma'am.
Okay. Why did that occur?
The investigation began into a drug investigation after me and another officer asked if there was any weapons present in the vehicle. At that time, the defendant began reaching down toward the right side of his seat after being instructed not to do so.
Okay. Did you ask to see his hands?
Yes, ma'am.
And was that before or after he began reaching?
It was after we instructed him to stop moving.
Okay. And why is it important for you to see his hands?
For safety, officer safety purposes. It could be a weapon present in the vehicle.
Okay. Did you all take any additional steps to ensure officer safety?
Yes, ma'am. We had him exit the vehicle, and after he exited the vehicle, the rest of the occupants exited.
Okay. And once they exited the vehicle, what steps did you take next?
After we exited the vehicle, we located a BB gun underneath the defendant's seat, and we also got consent from the owner, which was the driver, to conduct a search of the vehicle.
Okay. And you confirmed that the driver was the owner of the vehicle?
Yes, ma'am.
Okay. And after he provided you consent, in addition to the BB gun, what else did you find?
We located, I believe, 2 grams of methamphetamine in the driver's possession, 2 glass pipes that were in the cup holder in the constructive possession of both the driver and defendant, and a small amount of marijuana that was concealed underneath the defendant's seat.
Now, I want to bring your attention to the glass pipes that you located. You said that they were in a cup holder. Were they in the same cup holder or different locations?
From my recollection, I want to say they were in the same cup holder, and there was 2 of them.
Okay. I believe that you may have identified one as the passenger's cup holder and the other in the center console. Do you distinguish those, or are those the same?
The same.
How many cup holders were in the center console?
I believe 2.
Okay. So, I'm going to just be very basic. So there are basically 2 holes in the center console for cups.
Correct.
Okay. And the pipes were in which one, near the driver or the passenger?
So the cup holders are lined up. So there wasn't one that was closer to the driver or one closer to the passenger. Okay. If that makes sense, they were on top of each other.
Okay. They were on top of each other.
If you're looking down at the console, yes, ma'am.
Okay. So was it at the top or the bottom?
I believe it was at the top, closest to the gear shift.
Okay. And who located this?
I believe I located this.
Okay. Do you need to look at your report to refresh your recollection?
Yes, ma'am, if you don't mind.
Yes.
Okay. I believe Officer Christian located the methamphetamine and I located the glass pipes and the marijuana.
Okay. And so if your report says something different, would your recollection have been better then or now?
I'm trying to locate in my report. I don't believe I specify which one of us located the glass pipes. Like I said, Officer Christian was on the driver's side conducting the search, and I was on the passenger side.
Okay. I'm going to direct you about 4 paragraphs down.
Okay, yeah. It is documented Officer Christian located the glass pipes.
Okay. And specifically, where did he locate the pipes?
In the passenger's cup holder.
Okay. And you mentioned that there were other substances found, but were they in the area where the passenger was seated?
Yes, ma'am.
Okay. Do you know if these pipes were visible? Or did they have to be manipulated to be seen?
The pipes were visible.
Okay. And was there anything else of note about these pipes?
I believe they had burnt residue in them.
Okay. Now, as a Clayton County police officer, are you familiar with narcotics?
Yes, ma'am.
And are you familiar with items that are used to ingest or use narcotics?
Yes, ma'am.
And so in your training and experience, were you able to ascertain the purpose of the pipe?
Yes, ma'am.
Okay. And what was that?
The purpose of the pipe was used to ingest methamphetamine.
And was there any other descriptors of the pipe other than, I think you said it had contained something that was burnt?
Yes, ma'am.
Okay. Was anything able to be retrieved from the pipes or tested?
Unfortunately not.
Okay. Was the substance that you believe to be methamphetamine field tested?
Yes, ma'am.
Okay. Did anyone claim that substance?
No, ma'am.
Okay. And in addition to the pipes located in the cup holder, did you locate any other substances or paraphernalia?
There were, I believe, 2 additional pipes located on one of the rear passengers who was also arrested during this incident.
Okay. That was in the rear.
Correct.
And Mr. Gordon was in the front passenger seat.
Correct.
Okay. Was there anything else of note that you can recall about the vehicle or the defendant?
In regards to
your investigation?
No, ma'am.
Okay. Did you speak with the defendant about any of these items?
Yes, ma'am.
And did he provide any information?
On the glass pipes, I'm gonna have to refresh my recollection on the pipes. I don't recall.
Okay.
I'm sorry, ma'am. Are you waiting for me?
Yes.
Can you repeat the question? I wasn't aware that you asked me a question.
The question was, did the defendant make any statements about any of the items in the car?
I don't believe so, ma'am.
Okay. And you indicated that he was originally reaching when you initiated the traffic stop. Where was he reaching specifically?
He was reaching in the direction where the marijuana was located.
Okay. And where was that?
On the side of his seat, and it was crumbled up and concealed in a dollar bill.
When you say the side of his seat, are you referring to the side closest to the door, the side closest to the console?
The side closest to the door.
Your Honor, I don't have any further questions of this witness.
Thank you. Mr. Little?
Officer Ward, how many occupants were in the vehicle when it was stopped?
There were 5.
There were 5 people. And what sort of vehicle was it?
It was a sedan.
Sedan, like a 4-door passenger car?
Correct.
Okay. So there were 2 passengers in the front and 3 in the back?
There was a driver, a front passenger, and 3 rear passengers.
Okay, thank you. And the substance that you believe to be methamphetamine, you said that was discovered in the driver's possession?
Correct.
Where was that?
It was on the driver's floor in a black bag.
Okay. And then we talked about these glass pipes. They were in the center console?
Correct.
In a cup holder?
Correct.
How far from that cup holder is the back seat of this passenger car?
How far? You want me to estimate?
Yeah, just take a guess. Like, you saw the car, right? How far was the back seat from the cup holder?
Probably 1.5 feet.
So the people sitting in the back seat would have been able to reach the cup holder?
I don't want to speculate.
Okay. Now, only 3 people were arrested out of this traffic stop, though, correct?
That's correct.
The two of the rear passengers were not charged with any kind of possession?
That's correct.
Okay. Why were they not charged?
They weren't in possession of any drug paraphernalia or illegal substances.
Meaning that they didn't have any substances on their person?
Correct.
And they didn't have any drug paraphernalia on their person?
Or in their immediate reach.
Other than potentially in the cup holder that we don't want to speculate on?
Yeah, I don't want to speculate. I can't tell.
I gotcha. But you were able to tell that Mr. Gordon would have been able to reach those cup holders?
Correct.
I see. You also alleged there was a substance you believe to be marijuana found under the seat?
Correct.
Was that collected for evidence purposes?
I believe it was.
Okay. And was that field tested in any way?
I don't believe we had a field test at the time.
Okay. Did you request a warrant for that marijuana?
A warrant?
Yeah, to request an arrest warrant for one of the occupants of the car in relation to possession of that marijuana, the alleged marijuana.
Did I request a warrant? I did not request a warrant.
Okay. And it was your testimony that Mr. Gordon didn't make any statements about ownership of the pipe?
Not from my recollection.
Okay. And it was also your testimony that these cup holders are, I guess, in a line with each other so that there isn't one that's closer or further away from the passenger or the driver?
Correct. It was in constructive possession, so they were both charged with.
Right. I'm just making sure I understand the layout of the cup holders.
Yes, sir.
Okay. Thank you. Those are the questions I have at this time.
Thank you. Ms. Lewis?
Briefly, were there additional cup holders in the vehicle?
I'm sure there was probably some cup holders in the rear that weren't in use at the time.
Okay. And I think you mentioned, did you tell us how much the methamphetamine weighed?
Yes, ma'am. I believe it was just a little bit over 2 grams.
Okay. And so, I guess just in relation to, we would typically weigh marijuana in ounces. Do you know how that would compare? Would it be less than an ounce?
It was less than an ounce.
All right. No further questions.
Mr. Little?
No other questions this time, Your Honor. Oh, wait, I do have a question. Sorry. Officer Ward, I believe you testified that once the occupants of the vehicle were out of the vehicle, there was a BB gun located in the vehicle?
Yes, sir.
But you also testified that you got consent from the driver, Mr. Cross. Was that consent obtained before the gun was found?
So after the occupants exited the vehicle, we conducted a Terry of the vehicle after observing a holster in plain view. So that's when we located the BB gun. After located BB gun, we received consent to search the rest of the vehicle.
You did a Terry search of the occupants of the vehicle?
No, we did a Terry search of the actual vehicle.
Of the vehicle?
Yes, sir.
Interesting. Okay. Were there any people inside the vehicle when that Terry search was conducted?
No, sir.
Okay. Thank you. Those are the questions I have this time.
Anything else, Ms. Lewis?
No, Your Honor.
Any other witnesses for the state?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Argument?
We would just reserve rebuttal.
Your Honor, I would argue that the state has failed to meet their burden of probable cause to show that they had probable cause to believe that Mr. Gordon was in possession of this drug-related objects that were allegedly found in the car. The glass pipes were found in the center console of a four-door passenger vehicle that had 5 occupants in it. I know that Officer Ward didn't want to speculate, but my sense is that probably anybody in that car could have reached that center console and could have reached that cup holder. Mr. Cross, as the driver of the car, is presumed to be in possession of the contraband within the car. I did a little case law research on this, and I'm referring to get that point there that the driver is presumed to be in constructive possession. I was looking at Holloway v. State, which is a Court of Appeals case from 2009. That's 297 Georgia App 81 Holloway v. State. There it says that the driver of the vehicle is presumed to have possession of contraband in the vehicle. Now, it is a rebuttable presumption, but that rebuttable presumption requires that there actually be evidence that links the contraband to some other occupants of the car. My thinking here is that the rear passengers weren't charged with constructive possession for things that were in the cup holder in the center of the vehicle. Why then was Mr. Gordon charged with those items? He didn't make any statements that he was involved with the contraband in the car. He was just a passenger in the car, just like the people in the back seat were. This is somewhat different than the female passenger in the rear that had contraband allegedly in her possession on her person. And that makes sense why she might have been charged. But as far as Mr. Gordon, he is a passenger in this vehicle that had the same access to the cup holders that anybody else in the vehicle would be. And I would argue that the state then hasn't rebutted the presumption that it's Mr. Cross's items, since he was the driver and registered owner of the vehicle. Thank you, Your Honor.
Thank you, Mr. Little. Ms. Lewis?
Yes, Your Honor. So I'm very familiar with the case that Mr. Little cited to, as well as constructive possession. And when one of the main principles of constructive possession is that possession can be joint or sole. So that other people also could have been in constructive possession does not preclude a finding that the other person was also constructively possessing it under the law. In addition, while there is the presumption, that is actually a defense in a trial. And of course, trial is a different standard than probable cause. If the state tends to introduce evidence against the driver of the vehicle by way of the ownership presumption, then he is entitled to the defense to rebut that by saying that others have an equal access opportunity to the same contraband. And that is the way that the presumption would be rebutted. I have done that as a defense attorney, and I have entered the ownership presumption as a prosecutor. So those are two different concepts. The ownership presumption is a tool the state could use in its prosecution of the driver. The equal access argument would be his potential defense. But again, possession can be joint or sole. And that's a part of the jury charges on constructive possession. And so that they all were in possession of it does not preclude him from doing it. That one person wasn't arrested doesn't mean it. If we all rob a bank and one person gets arrested, it doesn't preclude the argument. It doesn't prove or disprove that you did or didn't also rob the bank. And I think that is the logic upon why you can be in sole or joint possession of something, even constructively. So based on those principles, while I do understand that certainly those are defenses that could be presented at trial, I think at this level, there is sufficient probable cause based on the testimony that it was in the open, so it wasn't like it was concealed, that it actually was burnt, which infers recent use, and that there were multiple pipes, meaning multiple people would be using it, as opposed to one, although certainly people can share a pipe. But at any rate, we believe at this point that probable cause has been established.
Thank you, Ms. Lewis. Based on the evidence presented before the court today, I do find that it's sufficient evidence to bind the charge of use of possession of drug-related objects over to state court. Thank you. You can take Mr. Gordon back. And bring us Mr. Bailey, please.
Defendant assist, Your Honor.
Bailey.
Okay. Thank you. And Mr. Steele will be handling that for the state.
Okay.
Hold on. Ma'am, did you call for Barry Thomas?
Yes.
Yes, please.
Yes, ma'am. Come on.
On that blue dot on the right.
Okay. You can say good morning, sir. Good morning.
And the court will now call the case of the state of Georgia versus Thomas Bailey. Case numbers 2021 CW 54369, 54370, 54371. Here representing the state via Zoom is Mr. Jonathan Steele. The defendant, Mr. Thomas Bailey, is present and is currently incarcerated in Clayton County Jail. Are you Mr. Thomas Bailey?
Yes, ma'am.
Okay. And Mr. Bailey is represented by Mr. Stephen Little. You all may proceed.
Thank you, Your Honor. Officer Watts, may you please raise your right hand? Do you swear to tell the whole truth and nothing but the truth, so help you God?
Yes, sir.
Thank you. Can you please state your full name for the record?
It's gonna be Devontae Watts.
And Officer Watts, where are you employed?
Clayton County Police Department.
And how long have you been employed there?
Approximately a year and 6 months.
And were you employed there on September 4th, 2021?
Yes, sir.
On that particular day, can you recall if you were called out to 505 Clara Drive, Riverdale, Georgia?
Yes, sir.
And is that location in Clayton County, Georgia?
Considered Riverdale. Yes, sir, it is.
And can you please indicate to the court why you were called out to that location?
I was called out to that location in reference to an accident with injuries.
And when you arrived on scene, did you speak with anyone?
Upon arrival on scene, I spoke with all parties, including Mr. Bailey. I immediately tried to render aid to the ones that were hurt.
And about how many parties were there on the scene, including Mr. Bailey?
I say 6 to 7.
And I kind of want you to break it down so that, you know, myself and the court can understand. The first party, essentially from most hurt to least hurt, can you please tell us just kind of what they said?
So what I was told was, as they were trying to back into their driveway, they were hit head on by Mr. Bailey. Everyone sustained some type of injury, whether it was a complaint or apparent serious injuries. I don't recall anyone. Well, actually, a few were transported. But other than that was as far as injury was.
So EMT did have to be called out to the scene.
Yes, sir.
And the people involved in this accident, did they identify Mr. Bailey as being involved in this accident as well?
Yes, sir. Mr. Bailey also identified himself.
And did you make contact with Mr. Bailey on scene?
Yes, sir.
And do you see him now in the Zoom call?
Yes, sir.
Can you describe an article of clothing or a distinct feature of Mr. Bailey?
Distinct feature of Mr. Bailey. I observed that he had braces in his mouth. He also has dreadlocks and tattoos.
And as far as you know, Mr. Bailey is wearing a white mask right now on the Zoom call.
Yes, sir.
Your Honor, please let the record reflect that the defendant has been identified.
Record is reflected.
And can you describe your contact with the defendant?
When contact was made with Mr. Bailey, I just wanted to get a clear understanding of what happened with the accident. He's very distressed due to the situation. I then immediately asked for license to help identify him for my investigation of the accident.
And going back to when you first arrived, you talked to the parties. How did they describe the defendant was driving?
They said he was driving pretty fast.
And how many lanes were on this particular road?
And being a subdivision, they're not marked, but it's clear there's 2 lanes.
And so you would describe the conditions as being a narrow driveway in a subdivision?
Yeah.
And when you consider the condition of this road, what would you consider to be just an estimate of a safe speed?
For a neighborhood, preferably.
Objection. I think it was just speculating what a safe speed would be. There's probably a marked speed limit on that road.
Correct.
So can you describe what the marked speed limit on that road was, Your Honor? Mr. Watts, excuse me.
Further said 15 miles per hour.
15. And the party stated to you, it appeared that he was coming at a high rate of speed.
Yes.
And in your experience as a Clayton County police officer, do you have experience investigating accidents on a regular?
Yes, sir.
So when you, regarding this accident, who was cited for the cause of this accident?
Mr. Bailey was cited.
And how were you able to conclude that the defendant should have been cited?
Because he was driving at a higher speed, and the subdivision is clearly marked at it's a subdivision. So if you have, the defendant can admit to driving at a higher rate of speed, plus witnesses stating that they saw him driving at a higher rate of speed. Yeah.
And so in your contact, did Mr. Bailey admit to you he was driving at a high rate of speed?
It wasn't clear as day that he was driving. He stated he was just driving.
And speaking of the cars that were involved in this accident, can you describe some of the damages that you observed?
There was extensive damage, disabling damage to the second vehicle with a majority of the party that was involved. I want to say it was heavy damage on the left side.
And did you observe any damages to Mr. Bailey's vehicle?
Yes, Mr. Bailey's vehicle was also suffered disabling damages. Upon the point of impact, Mr. Bailey's vehicle did flip and land back on all four wheels.
Was Mr. Bailey's car searched?
Yes, there was an inventory done on the vehicle for our tow truck inventory sheet.
And did you find anything of interest inside Mr. Bailey's vehicle?
Yes, sir. There was a clear bag with suspected marijuana inside of it.
And in your experience, do you encounter narcotics as part of the job?
Yes, sir.
And does that training experience help you to identify marijuana?
Yes, sir.
And so was this marijuana found on or near the defendant?
No, sir. He was already out of the vehicle.
So it was just purely in the vehicle?
It was in the vehicle.
Was it field tested?
No, sir.
Did the defendant claim the marijuana?
He did not.
Was anyone else located in the defendant's vehicle?
No, sir.
And can you estimate to how much marijuana was found in the vehicle?
It's roughly about 3 to 4 grams marijuana.
And compared that to ounces, that's like less than an ounce.
Less than an ounce.
Thank you. No further questions at the moment, Your Honor.
Thank you, Mr. Steele. Mr. Little?
Thank you, Your Honor. Officer Watts, were you the first officer to arrive to this incident?
Yes, sir.
Did other officers arrive to assist you later?
Yes, sir.
Okay. How many officers assisted you on this call?
Probably 3 or 4.
Oh, okay. Now, you said Mr. Bailey's vehicle, it flipped over, but then it landed back on its wheels?
Yes, sir.
Where was the vehicle when you arrived?
When I arrived, both the unit number 2 was pushed off of the roadway, and Mr. Bailey's vehicle was facing the other direction with the rear end facing towards the house in the middle of the roadway.
Like it had passed the house?
Yeah.
But it was still in the roadway. It wasn't like in someone's yard.
No. Yeah, it was in the roadway. Yeah.
Okay. Was there, and the witnesses described that this thing rolled all the way over?
Yeah, it rolled all the way over.
Was there damage to the top of it?
Yeah, it was damage on top.
Okay. Do you know where the alleged marijuana was found during the inventory search?
I believe it was found in the Senate console.
Okay. And is that something that has like a top on it that closes?
Yes, sir.
Okay. Did you speak to Mr. Bailey after the vehicle was inventoried?
I believe we did, to basically, hey, this was found in your vehicle.
Was he already in custody at that point?
No, sir.
Where was he during that questioning?
Actually, I take that. He was in custody because when I ran his OLN, he had a warrant out for his arrest.
Okay. So he was arrested as soon as you discovered the warrant.
Well, he was detained because we have to get confirmation.
I got you. When you say detained, does that mean he was handcuffed?
Yes.
Does that mean he definitely would not have been free to leave had he tried to leave?
Correct.
Okay. So when you ask him about the suspected contraband in the vehicle, was he Mirandized before that questioning?
No, sir.
Okay. Did he give any kind of response to it?
He did. He stated that it was not his.
Okay. Do you know who the registered owner of the vehicle is?
It's either Mr. Bailey's or family members. Cannot recall.
Okay. And was that something that was investigated during this investigation?
Yes, sir.
Okay. Was any attempt made to contact somebody? Well, actually, let me ask you. You said there was disabling damage. Was that vehicle undrivable after the accident?
Yes.
Okay. So it had to be towed.
Yes, sir.
I got you. What time of day was this?
It was late in the evening.
Was it already dark?
Not quite.
So like twilight, getting dark?
Yeah.
Okay. This happened on Clara Drive in Riverdale?
Yes, sir.
Are there any streetlights on Clara Drive?
Not that I can recall.
Okay, so you don't remember seeing any streetlights?
No, sir.
I got you. And then the alleged victims in this case, they're saying that they were trying to back into their driveway when they were struck?
Yes.
Does that mean that their car was in the roadway?
Yes.
Okay. Did they give any indication that they had headlights on?
That I cannot recall.
Okay. And also, Mr. Bailey, he was taken to, I think it was the hospital before he was arrested?
Yes, sir. For his injuries.
Do you have any idea of what those injuries were?
Upon detaining Bailey, he stated that he was having back spasms.
Okay.
The med unit wanted to check him out. He stated he wanted to go to the hospital.
Okay. Did you accompany him to the hospital?
Well, no, unfortunately, no.
Okay. So, I mean, did some officer go with him to the hospital?
Well, since he already had a warrant, well, actually, I had to go take out a warrant.
Okay.
But since he already had a warrant, I actually did have to go down there, but someone else came to sit on him so I can go do my other warrants.
I got you. And you said he was very distressed when you were first speaking with him. Was that due to his injuries? I mean,
no, it was due to the accident. Like he truly didn't mean to cause his accident.
All right. Thank you. Those are the questions I have at this time.
Thank you. Anything else, Mr. Steele?
Nothing from the state, Your Honor.
Okay. Any more witnesses for the state?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Argument?
Your Honor, the only argument I have onto this one goes to the too fast for conditions and the reckless driving, Your Honor. We don't really have any evidence of how Mr. Bailey was alleged to have been driving. We know he was the driver. We know there was a car accident. What we don't know is how he was driving and how those two cars interacted with each other. There's some evidence that there may not have been streetlights on this road. It was getting dark. We don't know whether or not the alleged victims had headlights on and where their car may have been in the roadway, obstructing the roadway. So this time around, I would allege the states failed to meet their burden of probable cause for at least the reckless driving and the too fast for conditions charge.
Thank you, Mr. Little. Mr. Field?
And Your Honor, I would just like to make note for too fast for conditions based upon there's no exact limit that we have to prove, just that the conditions of the road, Your Honor, would not have been suitable for high speed, which the witnesses in the case indicated to the officer. The officer noted he observed the accident, the injuries. Mr. Bailey himself had to be sent to the hospital, which would not have occurred, Your Honor, based upon an assumption of going at a speed to cause those damage and injuries, Your Honor.
Yeah, speak on that, Your Honor.
Not at this point.
Thank you, Mr.
Is that all, Mr. Steele?
That is all, Your Honor.
Okay. Based on the evidence presented before the court today, I do find sufficient evidence to bind all three charges over to state court. Thank you. Officer Watts, you are free to go if you don't have any other matters with the court, and you all can take Mr. Bailey back at the jail and bring us.
Yes, sir. You go back.
Thank you.
Porterfield. Porterfield, am I saying that right?
Yes.
Okay.
Yes, ma'am.
Oh, I gotta go.
Okay. Court will now call the case of the state of Georgia versus U Porterfield, case number 2021 WA 13498. Present for the hearing here via Zoom representing the state is Mr. Jonathan Steele. The defendant, U Porterfield. Are you Mr. Porterfield?
Yes, ma'am.
He's present and currently incarcerated in the Clayton County Jail. His attorney, Mr. David Suh, is also present. You all may proceed.
Thank you, Your Honor. Officer Bush, may you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please state your full name for the record?
Officer Charles Bush.
And Officer Bush, where are you employed?
Currently employed at the Clayton County Police Department.
And how long have you been employed there?
It is roughly 2 years. It'll be 2 years in December.
Okay. And were you employed there on July 18th, 2021?
Yes, sir.
And on that particular day, were you called out to 831 Jet Road, Jonesboro, Georgia?
Yes, sir.
And is that location in Clayton County, Georgia?
Yes, sir.
Can you please indicate to the court, excuse me, why you were called out to that location?
I was called out in reference to a male matching Mr. Hughes' description, older male, white male with a beard, holding a pry bar in his right hand, being at the residence at 04:52 a.m. in the morning. And he tried the door handle. It appeared that he was trying to break into the home. He tried the door handle, stood there for 5 minutes, and Ms. Gonzalez advised that she peeped through the window and saw the male standing out on the front porch. They called out to show us video footage because they were concerned about the male, possibly trying to break into their home. And this is not the first time that occurred, and they wanted us to investigate the incident.
Thank you for that. I'm sorry, I'm gonna backtrack a little bit because you hit on some very good points, and so I'm gonna kind of just break it down. Can I start with so this is a residential or commercial property?
This is a residential property.
And who did you speak with when you arrived on the scene?
I initially spoke with Mr. and Mrs. Gonzalez.
And to your knowledge, are they the homeowners?
Yes, sir.
And they stated to you they saw a male with a crowbar about 4:52 in the morning.
Yes, sir. The female did. The wife was at home. The male was not at home at the time. He was at work.
Okay. And what time did you arrive on the scene?
I arrived on scene. I was dispatched at 9:11, but I'm not sure approximately what time I arrived on scene.
Okay. Did you happen to make contact with Mr. Porterfield?
Yes, sir, I did.
And where did you make contact with him?
I made contact with Mr. Porterfield at his residence, not far from 831 Jet Road. It's a couple houses down at 805 Jet Road.
And when you made this contact, did he have anything of interest on him or the crowbar on him?
No, sir.
And so you just stated to me that the defendant lives a couple of houses down from the incident location?
Yes, sir. We were pointed out that house by the residents of 831 Jet Road. They gave us a physical description and they advised they lived a couple houses down.
So the defendant does not live at the incident location?
No, sir.
And to your knowledge, do the Gonzalez know the defendant?
They knew of him, but they did not know him personally. They just knew that he was someone that lived in the neighborhood and had done something like this before at other people's houses.
And you mentioned earlier about a video. Did someone show you a video?
Yes, sir. They have a Ring camera, door camera, and I observed it on Mr. Gonzalez's cell phone, and he showed me the footage that took place early that morning at 4 a.m., 4:52 a.m.
And the person you saw on this Ring video footage, are they on the Zoom call?
Yes, sir.
And the person that you made contact with that you believe was Mr. Porterfield, is he on the Zoom call?
Yes, sir, he is.
And can you please just describe him by either a piece of article they're wearing or something distinctive?
I best describe him about older white male with a beard. He wasn't wearing the exact clothing that he was wearing during the incident when I made contact with him.
And on the Zoom call, is he wearing a white mask?
Yes, sir.
Your Honor, please let the record reflect the defendant has been identified.
Record is reflected.
And so when you arrived on the scene, how were you able to identify that the defendant was the same individual at the Gonzalez's home?
I made contact at the door and I asked for Mr. Porterfield by name. A resident that lived there said, let me go and get him real quick. And he brought Mr. Porterfield to the door, and I identified him by asking for his information, his name, date of birth, and he gave me his name.
And he matched the person that you saw on this Ring video footage?
Yes, sir.
And did the defendant state anything to you during your encounter with him?
He did. He stated that he was at that home at that hour earlier that morning because he believed that someone he knew from high school lived at that residence. He said that he did try the doorknob a couple of times and he stood there. And then when Ms. Gonzalez peeped through the window, he realized that he realized that the female that he thought lived there did not live there, and he left the residence.
So the defendant stated to you that he was at the Gonzalez's home?
Yes, sir.
And he also stated to you that he went at about 4:52 in the morning to identify someone he may have not known?
Yes, sir.
And he also stated to you that he did try to doorknob on the Gonzalez's home?
Yes, sir.
Thank you, Officer Bush. No further questions.
Thank you. Mr. Seth?
Thank you, Your Honor. Hello, Officer Bush.
Hello, sir.
All right, let's just confirm a couple of things. So, Mr. Porterfield thought this was his friend's house for a period of time. Is that correct?
Yes, sir.
And then he realized it wasn't her house when he saw the actual homeowner in the house?
Yes, sir.
And he left immediately after he realized that?
Yes, sir. He left after he noticed.
All right. I want to focus on the videotape for a minute. You saw the footage, correct?
Yes, sir.
How long would you say that footage lasted for?
He stood there until 4:59. So he was there for about 5 minutes.
Were you able to see the beginning of when he arrived and when he left
in
that video?
Yes, sir.
Excellent. And would you describe, for those 5 minutes he was standing there, could you describe what you saw? Anything that stands out?
Okay, it mostly stands out that he tried the doorknob a couple of times. It never rung the doorbell itself as a normal person would if they were appearing at someone's house for a visit. He tried the doorknob and he had a pry bar in his right hand in the video, which would appear. Go ahead.
Did you ever see him use the pry bar besides just holding it in his hand? Did you ever see him use it in any way?
No, sir.
Did you ever see him even raise the pry bar in the video, or did it just stay in his right? I think you said right hand, right?
Yes, sir. Just stayed in his right hand.
Just stayed in his right hand. Okay. Did you see any damage to the door or the door frame?
No, sir.
Anywhere in that area, even, I don't know what could be next to the door frame, but any damage whatsoever?
No, sir.
Now, just to confirm, in the footage, this was approximately just before 5 in the morning, 4:52 in the morning?
Yes, sir.
Was it still dark at that time?
Yes, sir, it was.
That's all I have for now, Your Honor.
Thank you. Anything else, Mr. Steele?
Actually, I apologize, Your Honor. If I could apologize. I have one more question or one more line. I apologize, Mr. Steele. You mentioned that they said this happened in the past, the Gonzalez's. Is that correct?
Yes, sir.
Was there any type of incident report or police report related to those prior instances?
Not that address, no, sir. They just advised that it was a usual occurrence and that they'd heard from other neighbors that it had happened before at someone else's house in the same neighborhood.
Okay. All right. Thank you, Officer Bush. Apologize, Your Honor. Thank you.
Your Honor, I wanted to do a quick follow-up as well.
Okay.
Officer Bush, going back to the video, you stated you did see the defendant holding a crowbar, correct?
Yes, sir.
And can you just describe, with your training experience, cases of 5 o'clock in the morning at someone's house with a crowbar? I mean,
to my knowledge and experience, being out of that hour, being it was still dark outside and holding a pry bar, that could give any reasonable person cause to believe that you are there to break into their home or do some type of criminal act. And there's also not a reasonable hour to be at someone's home unannounced without, ringing the doorbell or calling ahead of time, being it is still dark out and him holding a pry bar in the right hand.
And at any point, did anyone say how long Mr. Porterfield has lived in this neighborhood?
No, sir.
And was there any indication from Mr. Porterfield as to why exactly he would think that this friend lived at the Gonzalez's home?
No, sir.
And did the Gonzalez's make any assumption to you at some point they knew someone that lived there that knew Mr. Porterfield?
No, sir. They didn't know anyone that lived there that knew Porterfield. They just knew that he lived a couple houses down.
Thank you, Officer Bush. Nothing further, Your Honor.
Thank you. Anything else, Mr. Sapp?
No, Your Honor.
Any other witnesses for the state?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Arguments?
I reserve for rebuttal, Your Honor.
Sir?
Thank you, Your Honor. Let's go through it. Your Honor, I think that we agree that Mr. Porterfield's actions are irregular, maybe even improper. But the question today is whether there's a probable cause of a crime occurring. Going through them, first one is criminal trespass. Your Honor, nothing indicates that Mr. Porterfield was told not to come to the residence. And I'm assured at this point now he knows that he's no longer welcome at that residence. But at that time, I don't see any evidence of a warning given or anything and allowing Mr. Porterfield to know that he's not allowed to be at that location. So I would argue that the state has not provided sufficient probable cause to charge for the crime of criminal trespass. To add to that, when it comes to criminal attempt, according to OCGA 1641, I quote, performs any act which constitutes a substantial step towards the commission of that crime. Performs any act which constitutes a substantial step towards the commission of that crime. At this point, and of course, because we're talking about burglary being the attempted alleged crime, I won't go into the details of that charge, but ultimately it does indicate that attempting of entry or breaking an entry into a dwelling, I want to say, is the focus there. Mr. Porterfield, even though he may have had a pry bar in his hand, nothing indicates he made any attempt of breaking into the house. He did try the doorknob, but he also left immediately when he realized that he must have made a mistake. This is not her house. No entry attempts on the door, no use of the pry bar whatsoever. And although the officer indicates a reasonable person, I would also argue that at 4:52 in the morning, a reasonable person might also walk around with some sort of weapon to defend themselves in case of random events, which could include a pry bar. I believe the key here is not that whether the pry bar, was in his hand, but whether he made any, the quote unquote, substantial step towards the commission of that crime. And I argue that holding a pry bar at 4:52 in the morning is not sufficient of a step. So I do ask that the court dismisses both charges for lack of probable cause. Both actions.
Mr. Steele?
Your Honor, based upon evidence, based upon, Officer Bush's testimony, being at your neighbor's house with a crowbar at 4:52 in the morning seems to be on the ledge of entering a property for an unlawful purpose. But even if such not, you find, Your Honor, OCGA 17-729, this court can commit for another offense if evidence supports it. And that would be loitering or prowling, Your Honor. A person commits that offense when they're in a place and time or manner not usual for law-abiding citizens. Your Honor, it would not be reasonable, it would not be understandable to be at someone's home at 4:52 in the morning with a crowbar, whether you know them or not, whether they're a friend or not. This seems to be a case where something is going on, Your Honor, and it's definitely an immediate concern for safety, which is why the Gonzalez's called the police, Your Honor. He lived in this neighborhood, so it's very unsure as to why he would not have known if his friend was still at this residence, if they ever had been, or if they had moved away, Your Honor. And for all these reasons, we are asking for this case to be found to have probable cause, Your Honor.
Thank you. Based on the evidence presented before the court today, I do find sufficient evidence to bind the case over to state court. You may be excused, Officer Bush, and you can take Mr. Porterfield back. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
And if you could bring us Mr. Simmons.
Okay, man. On the way.
Can I get my medication? Supposed to get my medication. Come
on, Simmons.
How you doing, sir?
Yeah, the judge is coming. Yeah.
Or we'll now call the case of the state of Georgia versus Tevin Simmons, case number 2021 WA 15797, 15798, and 15799. Present for the hearing here representing the state via Zoom is Mr. David Suh. The defendant, Mr. Tevin Simmons, is present. Are you Mr. Simmons?
Yes.
Okay. And currently incarcerated in Clayton County Jail. His attorney, I'm sorry. I said Mr. Suh is representing the state because I don't see Mr. Steele.
This is Ms. Lewis' case, Your Honor.
Okay. Ms. Lewis, is she ready? She step away.
I'm here, Your Honor. I was looking for Officer Sherwood.
Okay. All right. I'll hold for a minute. I kind of got ahead of myself.
And Your Honor, I'm sorry. I did receive an indication that Officer Sherwood was at a doctor's appointment, so we told them we'd let him know when we were ready for our case.
Okay, so we're going to hold on Simmons.
Can we take Solomon first while we contact Officer Sherwood?
Okay. All right. So if you will all just take, we're going to hold on Simmons. If you all would take Simmons back and bring us Cornelius Solomon, please.
Solomon.
They're gonna get you.
Solomon.
Solomon. Solomon? Solomon? Come on. You checking it,
What is it? Pick your box.
please say your first name is?
Huntley.
I see it's Cornelius Solomon.
No, Huntley McConnell.
You're McConnell.
I'm McConnell, yes.
We need Solomon.
Cornelius?
No.
Oh, that's not.
Oh, we need Solomon.
Solomon is down there in 11.
Let me ask, I have a waiver for Solomon, and then I have also that he was on for a hearing. I'm wondering if it's the same Solomon. I have Cornelius Solomon, and then I have a waiver for Solomon that was done on September 11th. Might have been his first appearance.
Is that for the same charge, Your Honor?
Yes, I have criminal trespass and use of possession of drug-related objects.
Oh.
I think I may have confused that because I think I thought Solomon was a waiver earlier, and I think Lister and Holt may have corrected me on that.
I actually have a waiver in my possession.
Oh, you actually physically have one. Well, in that case.
Yeah, that might be why you thought it was waived.
Yeah, that might be why. Thank you. And I don't feel crazy anymore. Okay.
Yeah, it looks like it was signed on September 11th by Judge Ferry. So like I said, I'm assuming that was done at first appearance.
That makes sense.
Okay. So that's waived. Then may we excuse Officer Gibson then?
Yes, Officer Gibson may be excused.
So that's not a waiver that we did. That was that they waived at first appearance.
Right.
Oh, okay.
Well, I don't know why it hasn't been bound over yet, but we'll check into that.
Your Honor, is that Cornelius Solomon?
Yes, ma'am.
Okay. So he can go back. Yes, ma'am.
Your Honor, my understanding is Officer Sherwood has now logged on.
Oh, okay, great. So we can do Simmons.
Yes, Your Honor.
Okay. Let's do Simmons. You can bring us Simmons back, Tevin Simmons.
Yes, man. I'm away.
Okay. Okay. The court will now call the case of the state of Georgia versus Tevin Simmons. Case numbers 2021 WA 15797, 15798, and 15799. Present for the hearing here via Zoom representing the state is Ms. Audrey Lewis. The defendant, are you Mr. Tevin Simmons?
Yes, ma'am.
Mr. Tevin Simmons is present and currently incarcerated in Clayton County Jail. His attorney, Mr. David Sugg, is also present. You all may proceed.
Thank you. Thank you for being with us, Officer Sherwood. I know you had another appointment, so we appreciate that.
Not a problem.
Officer Simmons, can you raise your right hand? I'm sorry. I said Simmons. I apologize. Officer Sherwood.
No, you're good.
Do you swear and affirm that the testimony that you shall provide to the court today shall be the truth, the whole truth, so help you God?
Yes, ma'am.
Okay. And can you state your complete name for the record?
It's Tiffany Sherwood.
Okay. And can you just spell your last name for the court reporter?
It's SHERWOOD.
Thank you. And Officer Sherwood, where do you work?
Clayton County Police Department.
And were you working there on September 4th of 2021?
Yes, ma'am.
And on this date, did you have the opportunity to encounter the defendant, Tevin Simmons?
I did.
Okay. And do you see him on this Zoom call?
Actually, no, I don't see him on the Zoom call.
Okay. Are you on a phone or tablet?
I'm on a phone, yes.
Okay. You may have to scroll so that you can see all the available screens.
Got you. Yes. Yes, I see him.
Okay. And can you identify him by what he's wearing?
Red, white mask.
Okay. Your Honor, may the record reflect that the witness has identified the defendant.
Record is reflected.
Thank you. Now, we mentioned that on this September 4th date, you came into contact with the defendant. Where were you when you saw him?
Terra Boulevard at Central Avenue in Jonesboro.
Okay. And not familiar with that area. Is there anything significant by way of a landmark over there or business? I'm putting you on the spot a bit.
You are. I can tell you that it was about a half a mile from where our officer was involved in an accident. It's on, there's a tire store, there's a snow cone store. We're a little bit shy of Valley
It's
Hill.
actually on like Terra Boulevard.
It is on Terra Boulevard. Yes, ma'am.
Okay. I'm familiar with that when you said the snow cone place.
Yep.
Okay. Was the defendant in a vehicle when you saw him?
In a Tahoe.
Okay. And did you make contact?
Well, it was a Chevy. It was a GMC Yukon.
Okay. And those are very similar.
Yes.
He was in this Yukon. Was he driving that vehicle?
Yes, ma'am.
Okay. And did you conduct a traffic stop?
I did.
Okay. What was the basis for the traffic stop?
His registration was suspended. It was hard to see the actual decal on the tag, so I ran it. Came back as suspended with no insurance. And then radio informed me that the defendant was actually wanted out of Henry County.
Okay. So a couple of things going on. So you were able to ascertain through a tag reader that his registration and insurance was not valid.
Through our MCT.
Okay. And is that connected to a database for
GCIC?
Gotcha. Okay. And so I'm assuming you made contact with him. Were you able to confirm that through speaking with him?
Yes. He stated that it wasn't his vehicle. He did give me his Georgia driver's license, which confirmed that, in fact, he was the one that was wanted out of Henry County.
Okay. Was the license valid?
It was not.
Okay. And how were you able to confirm that it was not?
Through dispatch, through GCIC.
Okay. And had he been previously cited for this?
Actually, yes. This was the third time he had been stopped on 5/11/2021 for a suspended driver's license. 7 days before that, on 5/4/2021, he was also pulled over for the exact same thing. This was his third offense in a 2-year period.
Okay.
He also told me that he had been pulled over so many times he couldn't even count in the back of my car.
Okay. And we described in great detail to this Terra Boulevard, Central Avenue area. But I have to ask you, what county was this in?
It was in Clayton County.
Okay. Thank you. I don't have any further. Oh, and was he able to ever produce anything showing valid insurance or registration?
No, ma'am. There was a female that was inside of the vehicle also. She called a male, but he was never able to provide an insurance card, never able to provide any registration. No.
Okay. Thank you. Your Honor, no further questions for this witness.
Thank you, Mr. Sun.
Thank you, Your Honor. Hello, Officer Sherwood.
Good afternoon.
Are you post certified?
I am.
And how long have you been post-certified?
Since June 16th of 2019.
2019. June 2019. Now, I want to jump to when Mr. Simmons was arrested. Did you read him his Miranda rights?
That I would have to go back and watch my body camera.
Okay. Not a problem. I guess that would lead to my next question is, did you have a body camera on you at the time?
Yes, sir.
And was that the body camera footage turned in and attached to this case in any way?
They're all downloaded.
I apologize. I asked that very weirdly. Is there a record of that body camera footage? That's probably the better question.
I would assume so. If my lights were activated, which they were, our body cameras automatically.
Thank you, officer. All right, let's see now. I believe the other questions were already answered. No, please. Okay. All right, no further questions, Your Honor.
Thank you. Ms. Lewis?
Your Honor, I don't have any redirect for this witness or any other witnesses in this case.
Okay, thank you. Any witnesses for the defense?
No, Your Honor.
Okay, argument?
State would reserve for rebuttal.
Your Honor, the defense submits on the evidence.
Okay. Well, based on the evidence submitted before the court today, I do find that it's sufficient evidence to bind the charges over to state court. Thank you.
Thank you very much.
You're welcome. Thank you, Officer Sherwood. You may be excused.
Thank you. Have a good day.
You too. You can take Mr. Simmons back. And if you would bring us Lee. Tyrese Lee.
Okay, man. Either way.
Thank you.
Just stand by.
There go Lee, man.
A report will now call. Do we have the officer on, Lee?
Sergeant Turnbull, Bull.
Sergeant Turnbull, would you turn your camera on, please, and your microphone? There you go. All right. The court will now call the case of the state of Georgia versus Tyrese Lee. Case numbers 2021 WA 15905, 15906, 15907, 15908, and 15909. Present for the hearing here representing the state via Zoom, Ms. Audrey Lewis. The defendant, Tyrese Lee. Are you? Oh, I'm sorry. Is it Mr. Steele? Okay, I see you both on here. So, okay, Mr. Jonathan Steele is here representing the state. The defendant, are you Mr. Tyrese Lee? Can you unmute him at the jail, please? Are you Mr. Tyrese Lee?
Yes, Your Honor.
Okay. Mr. Tyrese Lee is present and currently incarcerated in Clayton County Jail. His attorney, Mr. David Sutt, is also present. You all may proceed.
Thank you, Your Honor. Sergeant Tober, can you please raise your right hand? Do you swear to tell the whole truth, nothing but the truth, so help you God? Can you turn your volume up? I wasn't.
Can you hear me better now?
Yes, I can hear you great now. Can you please state your full name for the record?
Sergeant Akeem Turnbull.
And Sergeant Tober, where are you employed?
The City of Lovejoy Police Department in Clayton County.
And how long have you been employed there?
5 years.
And were you employed there on September 6, 2021?
I was.
And on that particular day, were you in the area or driving on McDonough Access Road in or near Hampton, Georgia?
I was.
And is that location in Clayton County, Georgia?
It is.
And can you please just indicate why you were in that area on the incident date, kind of what you observed?
Could you repeat the question?
Can you indicate to the court on the incident date, September 6th, what you observed?
I was driving on the roadway coming from Terra Boulevard onto McDonough Road. When I observed the vehicle turning onto the access road, the driver was not wearing a seatbelt. I activated my blue lights and sirens in an attempt to make a traffic stop of the vehicle. The vehicle continued driving, pulled into the parking lot as if the vehicle was going to stop. The driver then looked in his side view mirror, looked back at the police car, and then started rolling again. Activated the siren again, gave the driver several commands over the PA to stop, at which time he increased speed and which time a pursuit ensued. The vehicle went back onto McDonough Road towards Panhandle Road, disregarding red lights, overtaking vehicles, driving on the wrong side of the roadway. I continued to blare the siren and give the driver instructions to stop, in which he ignored. The driver ultimately pulled into a driveway, which I believe was his residence, and attempted to get out of the vehicle, at which time several officers were behind of me, and we took him into custody.
And can you tell us, was this at any point 2-lane road, 4-lane road?
It was a 2-lane road.
And was the driver's behavior safe for other drivers on the road?
No.
And as you mentioned, the driver did not obey traffic signals.
No.
The driver did not obey traffic signs.
No.
And when you attempted to make a stop, the driver did not initially stop.
The driver initially slowed down as if he was going to stop, pulling into a space, and then he looked back and then he took off again. So he never came to a complete stop, no.
Did the driver eventually stop?
Yes, once he got home.
And were you able to make contact with the driver of that vehicle?
Yes.
And is the person who was driving on the Zoom call?
Yes.
And can you describe what they are wearing right now on the Zoom call?
I don't know if I was trying to turn the screen. I can only see you right now. I know I saw a quick glimpse of him, but I only see you and
if you're on your phone, you might have to scroll left or right to see others.
Okay, yeah, I can see him now. He's wearing a white mask, and I can see the collar of an orange jumpsuit.
Your Honor, please let the record reflect that the defendant has been identified.
Record is reflected.
And did you have the defendant search through GCIC or a database system?
Yes. I know he did not provide me, I don't think he provided me with an ID at the time when he was detained. And I searched him by name and date of birth, and he came back to not be licensed.
And did you have a second check done? Dispatch at the police department? Oh, I think did we lose you?
Hello?
Okay.
Yeah, it's going in and out. All right, there you go.
Okay, and so did you have another check done from dispatch at the police department?
Yes, I checked it through the radio, yes.
And did it return that the defendant had a valid license?
No.
And when you, after making contact with the defendant, did you ascertain if he owned the vehicle?
He said the vehicle belonged to his mother, and that was the reason why he ran. he said that he was trying to get the vehicle back to his mother because he knew that he would be going to jail because he did not have a license, and that he thought that the vehicle would be towed, and that his mom didn't know that he had the vehicle. So he figured if he at least made it back home, even though he was going to jail anyway, that she would have the vehicle. I think that's what he said.
And at any point, did you ever make contact with the defendant's mother?
I did. She came out. There were several police cars outside. She heard the sirens as we're approaching because we're in a full pursuit. So she came outside after hearing the commotion and identified herself as the owner of the vehicle.
And did she state of anything of interest to you during your encounter?
She said that she didn't even know that he had the vehicle, that she didn't give him permission to get the vehicle. And she wrote a statement saying that she was sleeping and that the only way he would have got the vehicle would have been to remove the keys out of her purse while she was sleeping without her permission.
So the defendant did not have permission to take the vehicle?
No.
The defendant did not have permission to be in possession of the vehicle?
No.
Can you describe the make and model of the vehicle?
That I do. I know it was a grayish sedan 4-door. I don't remember the make and model.
Okay.
I'd have to look at my report.
Do you have your report handy?
I do. Hold on one second. It was a gray Nissan Versa with a Barron, Georgia tag, Charlie Ida Frank 3293.
At any point, were you able to determine the value of the vehicle?
The value of the vehicle was listed on there. Hold on. I believe it was listed as $23,000. Hold on. Let me double check. It's listed as $21,000.
And so my assumption is that once you stopped, you were able to locate the vehicle.
Yes.
And was the defendant in or near the vehicle when it was located?
Yeah, he opened the door in an attempt to get out as he parked, and he was ordered back into the vehicle and then was taken into custody. So he was in the vehicle when he was taken out.
Thank you, Officer Turbo. No further questions, Your Honor.
Thank you, Mr. Steele. Mr. Sugg?
Thank you, Your Honor. Hello, Sergeant Turnbull.
Hey, how are you doing?
How are you doing, sir? Are you post-certified?
I am.
And how long have you been post-certified?
Since 2009.
2009, all right. Now, do you wear body camera, personal body camera, a personal body camera device?
I do.
And was that recording at the time of this incident?
I believe it was.
Now, you also said that you indicated you saw a lack of a seatbelt. Just want to confirm, how did you, just to clarify, how did you confirm that a seatbelt was not being worn?
When I initially drove past the vehicle, we're on a 2-lane road. He was traveling the opposite. He was traveling south. I was traveling north. So we literally drove past each other. The vehicle isn't tinted. I looked at him and he didn't have his seatbelt on.
And you said, and just to confirm, you said it was not tinted?
No, it's not.
Okay. And just to estimate, how many feet would you say you were away from him when you saw this?
The length of the lane divider, because like I said, it was a 2-lane road and we literally rode right by each other. So if my window was down, I could reach out and touch the vehicle.
So about the distance between two cars being next to each other?
Yep.
Okay, gotcha. All right, and I think I might just have one final question. So you mentioned that you've turned on your blue lights and you had your sirens on at one point?
Yes.
And then eventually the accused did stop at his home?
Yes.
Can you give an ETA about how long did it take between the moment the lights were on and the moment he got home?
I would say about 6 to 7 minutes. We were on McDonough Access Road, went to McDonough Road, then went to Panhandle Road, then several side streets, then coming back onto Terra Road, turning into his subdivision. About 7 to 8 minutes of pursuit lasted.
Okay. Thank you, officer. No further questions, Your Honor.
Thank you. Anything else, Mr. Steele?
I just have one more question for Mr. Turnbull. Between that 6-7 minutes, I just want to clarify, at any point, did Mr. Lee drive onto oncoming traffic?
Yes, he did at least at 2 separate. I know he did at the McDonough Road and Panhandle Road intersection when he went through the red light. And once on Panhandle Road, I'm not sure of the cross street, but he crossed over into lanes to which one vehicle had to go off the roadway to get out of his way.
Thank you so much, Sergeant. No further questions, Your Honor.
Thank you. Anything else, Mr. Sir?
No further questions, Your Honor.
Any other witnesses for the state?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Argument?
I'll reserve for rebuttal, Your Honor.
We'll submit on the evidence.
Okay, based on the evidence submitted before the court today, I do find that there's sufficient evidence to bind all charges over to state court. Thank you. You all can take Mr. Lee back, and please bring us Mr. Reed.
Am I free to go, Your Honor?
Yes. Thank you, Sergeant Turnbull. Yes, if you could bring us Kelvin Reed at the jail.
He's on his way now.
Okay, thank you.
Read. Kelvin Reed.
Read. You probably don't want it on the single.
Now, read 24. He was in a single cell.
Okay.
I guess I'll come back later. Hook it up, or you not hook it up too?
I'll have you come back later.
All right, sorry.
Come on. Come on. It's okay. They gonna come on. Right. Oh yeah, this is I didn't see that. Yeah. You don't go in the shower and you put on 31 for the bed.
Like some point, turn man side out.
I mean, if you want to kid.
Okay, do we have the officer on read?
Yes, Your Honor, we do. It's Officer Sharp.
Sharp, Officer Sharp, if you would turn your camera on and unmute your microphone.
Hi, Your Honor.
Hello. Can you turn your camera on? We still can't see you. Officer Sharp, can you hear us?
Yes, I'm trying to turn it on, Your Honor.
Okay.
Hi, Your Honor.
Okay. All right. The court will now call the case of the state of Georgia versus Kelvin Reed, case number 2021 WA 16052. Present for the hearing, here representing the state is Mr. Jonathan Steele. The defendant, Kelvin Reed, is present. Are you Mr. Reed?
Yeah.
Okay. He's present and currently incarcerated in Clayton County Jail. His attorney, Mr. David Suh, is also present. You all may proceed.
Thank you, Your Honor. Officer Sharp, may you please raise your right hand? Do you swear to tell the whole truth and nothing but the truth, so help you God?
I do.
Can you please state your full name for the record?
Officer Dwayne Sharp.
Officer Sharp, where are you employed?
Clayton County Police Department for approximately 7 years.
And were you employed there on September 9th, 2021?
I was.
And on that particular day, were you called out to 4000 Old Dixie Road, Atlanta, Georgia?
I was.
And is that location in Clayton County, Georgia?
It is.
And can you please indicate to the court why you were called out to that location?
I was called out due to a male being inside a vehicle and would not get out of the vehicle after being told to by the employee and staff.
And when you arrived on the scene, did you speak with anyone?
Yes.
And do you know who you spoke with?
Give me one moment.
Okay.
I spoke to, I'm probably going to butcher this name, but Oliviera. It's a female, 34-year-old female.
No, you're fine. That's Oliviera, how I would have pronounced it too. And what did she state to you what happened?
She stated that she works at that location, and when she arrived, the male was inside of the vehicle. She stated that she opens up the location. She's one of the employees at the location that she opens it up. And when she arrived, the male was inside the vehicle sleeping. She told the male several times to get out the vehicle, and he wouldn't.
And based upon you saying opening up, this is a commercial property, correct?
Correct. It's a parking lot where they sell 18-wheelers, tractor trailers.
And the person Mr. Oliviera described to you, is he on the Zoom call?
Give me one moment. Let me confirm. Yes, a male wearing a orange jumpsuit and a white mask.
Your Honor, please let the record reflect that the defendant has been identified.
Record is reflected.
And did Ms. Oliveira, did she tell you about when she found the defendant?
Yes. She stated she found him that morning when she arrived at work.
And can you please tell us again where she found the defendant?
Inside of a vehicle, inside of one of the vehicles that they have on the property.
And you stated earlier he was sleeping when she found him?
Yes.
Was he a customer?
No.
Was he an employee of this establishment?
No.
Did she ask the defendant to leave the premises?
Yes, she did.
Did the defendant leave after she asked him to?
No.
Can you kind of tell us why she called the police?
She called because he became aggressive once she told him to leave, and she felt like law enforcement presence was needed.
Was he on the scene when you arrived?
Yes, he was. He was still inside the vehicle.
And did Ms. Oliveira ask the defendant to leave while you were on the scene?
Yes.
Did he leave then?
No, I asked him several times to leave also, and he still wouldn't leave. At one point, I tried to open the door to the vehicle, and he locked the door, having me to walk around to the other side of the vehicle and go in through that way. And I then told him to get out the vehicle again. He then continued to refuse to get out of the vehicle, but after speaking with him for several minutes, I was able to coax him out of the vehicle.
And did the defendant state to you at any time that he entered the premises without permission?
Yes. I asked him how he got into the vehicle and how he got onto the property. He said he went over the fence.
Thank you, Officer Sharp. No further questions, Your Honor.
Thank you. Mr. Seth?
Thank you, Your Honor. Hello, Officer Sharp.
How you doing, sir?
I'm pretty good. Few questions. Are you post-certified?
I am.
And how long have you been post-certified?
Approximately 7 years.
Okay. Let's see now. Do you have a body-worn camera?
I do.
And was it activated on the day in question?
Yes.
And regarding the complainant, I'm probably going to butcher the name as well. Miss Olivera. Did she fill out any type of witness statement or any other form?
I don't believe she did. If she did, it would be attached to the report. I can't recollect at this time if she did or if she did not.
All right, thank you, Officer Sharp. That's all I have, Your Honor.
Thank you. Anything else, Mr. Steele?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Argument?
I reserve for rebuttal, Your Honor.
Defense will submit on the evidence.
Based on the evidence presented before the court today, I do find that there's sufficient evidence to bind the one charge of criminal trespass over to state court. Thank you.
Thank you, Your Honor.
You're welcome. You could bring us. You're welcome.
Okay.
Stop. And I have